the instruction to withdraw the matter. 1818.
Item 18. Heard Mr. N.J. Khatonia, learned counsel for the petitioner. Stop. Also heard health.
Help, sir.
Anyone? Health?
Mr. Upamanu is there, my lord. In fact, I have informed him.
Also heard Mr. D. Upamanu, learned standing counsel. Health. Stop. Mr. Khatonia, learned counsel for the petitioner, submits that he has received instructions from the petitioner to withdraw the writ petition and accordingly makes an endorsement to the same effect. In view of the aforesaid endorsement made by the learned counsel for the petitioner, the writ petition stands dismissed on withdrawal.
Oblige, Lordship.
May I please, Your Lordship? I beg to mention item number 21 to 23. Lordship, in this case, MS Diborgo is arguing. Lordship, she is not well. Lordship, kindly matter will come after 1 week. Lordship.
21 to 23?
23, Lordship.
MS Diborgo is not well.
Not well, Lordship.
It is submitted by Mr.
P. Guhai, Lordship.
P. Gohai, learned counsel for the petitioner, that the arguing counsel MSD Borgohai is indisposed and accordingly seeks accommodation in the matter. Prayer is not opposed. List this matter again
After
on such
1.
and such date.
After 1.
May
18 or
please-
matter?
May it please, Your Lordship. With consent of the other side, I beg to mention item number 12 of today's list, my lord. 12 of today's list, my lord. I have already submitted the request slip, my lord.
Yes, you had circulated advance adjournment.
My lord.
You are for
Petitioner, my lord.
Mr.
UK Das, my lord.
Mr. UK Das, learned counsel, appearing for the petitioner, seeks
Adjournment only for today, my lord. Next week
seeks
is my
accommodation in the matter. Stop. It pertinent that advance adjournment slip was circulated yesterday. In view, prayer is allowed. List after 1 week on a date to be fixed by the registry. List on such and such date. Next week.
Next week.
May I please, Your Lordship? Item number 17, my lord. The case is infrastructure. Actually, the case of matter of regularization, but petitioner is assigned with another job. Case is infrastructure.
Mr.
G. Pathak.
G. Pathak, learned counsel for the petitioner. Stop. Also heard learned counsel for the petitioner, right? Also heard, yes, CGC. CGC, anyone? Item 17.
17.
Anyone, CGC? Your name is not there otherwise.
No, B. Sharma.
Mr. So-and-so on behalf of Mr. B. Sharma Kohli. You inform someone from the CGC and inform the name. We'll put it. Also heard so-and-so, standing counsel CGC. Okay, go for it. Inform Kohli, huh? Mr. So-and-so, learned counsel for the petitioner, submits that the matter that during the pendency of the writ proceeding, the matter has become infructuous and accordingly makes an endorsement to the same effect. In view of the above endorsement of the learned counsel for the petitioner, the writ petition stands closed on being infructuous.
Must.
May I please, Lordship? Concern on the other side, I beg to mention item number 24, Lordship.
2-4.
24.
Yes, what do you want?
Lordship, adjournment.
You are for?
I am for the petitioner.
You
And
want
for the respondent, Lordship.
how many? How you want adjournment for how many weeks?
Any day, Lordship.
Only not today.
Today, Lordship.
As prayed for by MS
December. J. Gogoi.
J.
On behalf
Gogoi.
of J. Gogoi on behalf of PP Bora.
On behalf of Mr. BP Bora, learned counsel for the petitioner, which is not opposed by MS
K. Bhattacharya.
K. Bhattacharya, learned counsel appearing for respondent number
229.
229.
On behalf of B. Senapati.
List this matter again on such and such date.
December.
Obliged.
May I please, Your Lordship? I beg to mention item number 27.
Yes.
It may be passed over for the day. As senior advocate, K.N. Chaudhary sir is out of station today.
It is submitted at the bar that Mr. K.N. Chaudhary, learned senior counsel, leading the brief on behalf of the petitioner, is out of station and accordingly an accommodation has been sought for. Prayer is allowed. List after 2 weeks on a date to be fixed by the registry.
Obliged.
Lordship, I beg to mention item 13 of today's daily list. Lordship, in this matter, Lordship, the petitioners are suffering from stagnation, Lordship, and there are some juniors who have been promoted subsequently. So the names of those, Lordship, I have sought for the names of those, but that instruction as of
You
now,
want to make some impediment?
not exactly, Lordship, but then they must also get those benefits, Lordship.
No, what is your prayer today, Mr.
For
Counsel?
adjournment till I get those instructions.
You are Mr.
I am MP Sharma, Lordship.
MP Sharma. Mr. MP Sharma, learned counsel appearing for the petitioner submits that certain instructions are awaiting in the matter and accordingly seeks accommodation. Prayer is allowed. List after 2 weeks of the December that they did. List on such and such dates.
Lordship.
May I please, Your Lordship? Lordship, my senior is undergoing a surgery, Lordship, today.
I have fixed in December.
Lordship, in January, Lordship.
In the meantime, MS.
M. Burman.
No, further MS M. Bormont.
M. Burman. On
Learned
behalf
co-
of Mrs. A. Gayan, Lordship.
Learned counsel on behalf of MS A. Gayan.
Lordship.
Learned counsel for the respondent submits that MS A. Gayan, who is leading the brief on behalf of the respondent, is undergoing a surgery
Lordship.
and accordingly seeks posting the matter for hearing in the month of January.
I'm obliged, Lordship.
Yes, you can call the list. Hearing material প্রথম হি পাঠ করতে দিবা ছাত্রী খালি আছে
Lordship, I am seeking for an adjournment, Lordship.
Same ground.
Same ground, Lordship.
Anuradha Gayan.
Anuradha Gayan, Lordship.
What surgery?
Lordship, uterus, Lordship.
As prayed for by MS
M. Burman.
M. Borman, learned counsel, on behalf of MS A. Gayan, learned counsel, appearing on behalf of the respondent to the effect that the learned counsel is undergoing a surgery. Comma, list this matter when?
January, Lordship.
Date may be fixed.
On such and such date. Did you about January?
Lordship, can it be in December? December.
She will not be back.
No.
She's undergoing some surgery.
9 January. Obliged, Lordship.
Yes, Mr. Parvat?
My only thing, my lord, my junior, he's kindly be for the timing, man. For the timing, for the timing.
No problem. Yes.
My lord, the matter part is non-payment of pensionary benefit, my lord. The petitioner was a master roll worker, my lord. Master roll worker, my lord.
Yes.
He joined in service on 1/1/1992.
This is for recovery of excess salary.
And my lord, two prayer is there, my lord. One, my lord, pensionary benefit, my lord, and another is, my lord, recovery, my lord.
Affidavit is filed by R2.
R2, my lord.
Yes, ma'am. You want to say something?
Lordship, Mr. P. Naik is appearing for BTC. He's on legs, Lordship. Matter may be taken up after some time.
Next week.
My lord. It may be fixed, my lord.
It is submitted that Mr. P. Nayak, when a standing counsel BTC is on legs in relation to another case before another court. List again next week on a date to be fixed by the registry.
All right.
Item 5.
This is for final hearing.
Mr. Dhar, you are scaring the court with that bag you are carrying.
My lord, this morning I have received the records. I don't know what is there, my lord. I have also,
There is nothing, my lord. Your lordship will see.
My lord,
2 points, my lord.
my lord, then my senior must be knowing what is there in the records, my lord, because I don't know, my lord. I have just received it.
No, my lord, look at, my lord, how many dates they have taken.
My lord, these are old matters.
You received the records today.
Dated
Mr.
nine-
Dhar, you have
Yes,
received
ma-
the
yes,
records
madam.
today.
Yes, my lord.
So you have a look at it. I'm posting it for hearing on Monday.
Please, my lord, please.
Tuesday.
Tuesday.
Tuesday is a hearing date.
Hope he will not say anything else.
No,
Mr. R. Dhar, learned State Counsel submits that the
That I don't
record
see.
as called for earlier by this court has been received today morning and accordingly seeks a short accommodation to go through the same. Prayer is allowed. List again on Tuesday, such and such date.
This will come for admission hearing.
Yes.
May I please, Your Lordship? Here in this case, my lord, correction of petitioner's date of birth method. What happened in this case, my lord, the petitioner's civil service has been regularized on 110.
I'm not being able to hear you.
My lord, here in this case, my lord, the correction of date of birth method.
Correction of date of birth.
Yes, my lord. And here in this case, my lord, the petitioners have their service has been
Mr.
regularized.
Dhar, you're appearing in this matter.
My lord, we have filed an affidavit also.
Hmm.
My lord, we tried, my lord, but it's because of the finance department, my lord, OM, we could not, my lord.
Finance is there, Mr. Nayak.
Finance has filed an affidavit, I'm told, my lord. So, correction.
Yes, affidavit. Two affidavits are on record. One by R4, one by R2. Who is R2?
R2, I think, my lord.
R2 is finance department.
Finance department.
Yes. What is the objection of the finance?
Okay, one OM is there.
Where?
Page 125.
Yes, 125. Yes, what do you want to rely? SR8?
Sorry, it's relating to correction of date of birth.
Yes. Please read, Mr. Nayak. Which
it
part
states
you want to rely?
Not if in case of government servant whose year of birth is known. It is not connection. Sir. It is not. Correction of date of birth. Yes.
Yes.
You're not prepared?
No, Lordship. I will take some time.
Then I'll have it on another day.
Lordship.
As prayed for by Mr. P. Nayak, Leonard Standing Council, Finance, list this matter again on, yes,
My lord, let me be candidate.
One. After.
on such and such date.
My lord. Obliged.
Yes, Mr. Chaudhary?
Yes, my lord. This matter, my lord, this is the case for praying for a pay protection, my lord. So this
Pay protection?
Pay protection. Initially, my lord,
Affidavits are completed?
affidavit is completed.
My lord, yes, we have filed affidavit, my lord.
You don't want to
My-
file rejoinder?
No, my lord, one affidavit we are going to file means all this process is there.
You are going to file?
Yes.
Then I'll post it. How much time you want?
It's around 27, ma'am. Today we will filing it, ma'am. Today we are filing.
You file it, then when do I post the matter?
27 file.
27.
Yes, ma'am.
Mr. K.H. Chaudhary, Leonard Senior Counsel, assisted by Ms. Shri S. Mukhtar,
Yes.
Leonard Counsel for the petitioner, submits that an affidavit in reply against
No,
the-
an affidavit.
Huh?
An additional affidavit.
An additional affidavit is going to be filed within the course of the day.
Yes.
And accordingly, stop. In view of the above, list this matter again on
27.
27/11/2024.
As you wish.
কপিটো দি দিব মোক হা বুকি দিব বেলেগক দিলে আকৌ হেৰাই যাব
7+1.
In this case also, my lord, no affidavit has been filed, my lord.
Yes, Mr. Nayak.
Affidavit has not filed, Lordship, but Lordship may kindly see the affidavit, Lordship. Kindly see the affidavit at page 20, Lordship.
20.
20. Lordship may kindly see the date, Lordship. I mean the age, Lordship.
Age.
Is 75 years, Lordship.
Yes.
If it is 75 years, Lordship, he should retire on 2008.
Accordingly, the pension proposal is processed, my lord.
You file your affidavit,
My
Mr.
lord,
Nayak.
Yes, Lordship, affidavit has not filed.
You file it. How much time?
Lordship, I have to obtain instruction, Lordship. I am
You
praying for
see,
three-
Mr. Nayak, this court's order in October was very clear.
Yes, Lordship.
The court had made it, had clarified
In fact,
that
Lordship,
return should be positively filed by the next date of listing.
Lordship, in fact, in this case, Lordship, we reminded the authority 3 times, Lordship. On 3 occasions, we wrote to them, Lordship, not yet received any instruction.
All right, so I'll say I'll give you time, and failing which I will direct personal appearance of the authority.
Lordship, that will be better.
Mr. P. Nayak, Learned Standing Counsel for Finance,
BTC, Lordship.
for BTC, Learned Standing Counsel BTC, seeks further 3 weeks' time to file the return in the matter. Stop. It appears that by order dated 3/10/2024, it was clarified that if return is not positively filed by the next date of listing, no, sorry, Bhargav. Please read that last sentence. It was clarified that return should be positively filed by the next date of listing. However, Mr. P. Nayak submits that despite repeated reminders, instructions are awaiting. Stop. Be that as it may, as per the assurance given by Mr. P. Nayak, this court, by way of last chance, directs the respondent BTC to file the return by the next date of listing, failing which the erring respondent official shall either be either personally or through video conferencing mode be present on the next date of listing. List again on such and such date after 3 weeks of the date. All right, Mr. Nayak?
Lordship.
I suppose this might facilitate the return.
I believe, I hope, Lordship.
Let's hope.
Lordship.
Make Mr. Lordship.
My lord, I am appearing on behalf of the private respondent, my lord. You want short time, my lord, to file a rejoinder, my lord. Everything.
Respondent.
Yeah, I responded.
Respondent rejoinder.
My lord, they have stated some new facts, my lord. Who have
No, but respondent.
private respondent, my lord. Dispute is with the private respondent, my lord. Family pension.
Otherwise, if I may interject here, Your Lordship, the issue as such is covered by.
All right, Mr. Bora, let him file his affidavit.
Otherwise, Your Lordship, it is helpful for both the parties actually, because the dispute.
Have you filed your affidavit?
We have not filed an affidavit.
Then
but
why
the law
file your affidavit?
There is a recent judgment of the full bench. If I may just quote that particular citation, 2022 SCC online, Guwahati, page 2000, in writ appeal number 160 of 2018. Therein, this issue of division of pension between two Mohammedan wives has been settled.
Have a look.
Let them have a look at
Have a
it.
look. As prayed for by Mr. A.R. Sikdar,
My lord.
Learned Counsel appearing on behalf of the respondent number 8, list this matter after
My lord, what? After a week, my lord.
after 2 weeks to enable the
168,
said respondent file counter affidavit in the matter
160.
2018.
on a date fixed.
Date may be given, Lordship.
All right. Yes. So we finished with the. Huh?
Lordship, Mr. R. Borpujari, he's on legs, my lords, in court number 13. Lordship, may pass over the matter for the time being, Lordship.
I can start the dictation.
Lordship, he has the record, Lordship. His,
Huh?
his submission might be required.
Mr. Patwari, you had mentioned one case law yesterday.
Yes.
You're carrying it?
Yes.
You give it to me that I just wanted to have a look at this.
Obliged.
Ask him to be here
Yes,
because
he's on legs, Lordship. He'll be after.
I am clear in my mind.
Lordship.
I want to get rid of
Lordship.
it. Yes, Mr. Sharma.
I was there in item number 8, my lord.
Item number 8.
Ma'am, Uda
8, I think some. Mr. Sikdar had taken time for filing affidavit. Kuntu Matila? 9. Yes.
May I please it?
Mr. Nath, you are appearing in this matter.
I'm appearing for respondent number 2.
Respondent number?
2.
Affidavit doesn't appear to be.
We have filed.
You have filed? There is no index here.
Secretary, we have filed on 19/9/24.
When?
19/9/24.
I don't think it is on record. 9 itla aru kiba ase niki file? It's not on record.
I'll check out.
Mr. D. Nath, learned counsel, appearing on behalf of respondent stroke contender numbers 2, contender number 2, submits that an affidavit in opposition was filed. An affidavit in opposition has been filed on
19 September 24.
19/9/2024. You have received?
No, Lord.
You have not received.
No, I have sought the copy, Lord. Yes, I have received, Lord.
Then why are you saying no?
Respondent number 2, Lord.
Mr. M. Soikia,
M. Soikia.
learned counsel for the petitioner, affirms the receipt of the same. However, the same is not available on record. Let registry verify and place the said affidavit in opposition on record. List next week on a date to be fixed by the registry. You want your appearance to be recorded?
Waiting for instructions.
You will file something. In the meantime, MS
And Bora.
N. Bora, learned counsel for the respondent
number
stroke contender number 1, seeks how much time? 2 weeks time to file return in the matter. Prayer is allowed here to this goes to next week or that after so and so forth.
I am appearing for respondent number. Today I am appearing for, so we need
How much time?
3 weeks time maybe.
Anybody else appearing? Miss MS N. Bora, learned counsel, appearing on behalf of respondent contender number 1, enters appearance and seeks 3 weeks time to file return. Prayer is allowed. List after 3 weeks on a date to be fixed by the registry.
Lordship, a step was taken on 5/10/24 upon the respondent number
Huh?
145, Lordship.
Sorry?
Step was taken, Lordship. Respondent number 1, 4, and 5, Lordship. So, report is awaited.
You are appearing for
2 and 3.
4 and 2 and 2 and await service in respect of respondent numbers 1, 4, and 5. In the meantime, Mr. D. Bora, learned counsel, enters appearance on behalf of respondent numbers 2 and 3. Stop. Ms. Bora, learned counsel for the aforesaid respondent 2 and 3, seeks how much time?
Lordship, 2 weeks time. Maybe
2 weeks time to file return in the matter. Prayer is allowed. List after 2 weeks on a date to be fixed by the registry.
Much obliged.
Supplementary orders 29.
Yes, Mr. Vishwakarma.
This is a contempt against the non-compliance of an order.
Yes, service is complete.
Service is complete. They had appeared. In fact, on the last occasion, they had sought time to file affidavit.
Who is appearing for the other
Mr.
side?
S. Bora was appearing.
Santanu Bora?
Yes.
Where is he? Mr. Bora? He's not there today.
No, may I point out a thing in this matter? Because in the writ petition, there were 2 sets of
No.
writ petitions.
Yes.
There were 2 sets of writ petitions. So both were disposed of by common order. So in the other writ petition, the petitioner therein had already filed a contempt. That
Mr. Bora? No problem, no problem. You can
Allow me 3 weeks time to file the affidavit, my lord.
let him file his affidavit.
The other contempt has already been disposed of.
Other contempt, same issue.
As prayed for by Mr. S. Bora, learned counsel, appearing on behalf of the respondent contender number, sole respondent contender, list this matter after 2 weeks on a date to be fixed by the registry to enable the said contender to file return in the matter.
Date be fixed.
Mr. Vishwakarma, it will come.
And 14 and 15 for hearing.
Mr. Borpujari is still not here.
May I please, Your Lordship? Matter pertains to item number 14 and 15, both the similar nature. Matter pertains to the
Promotion
to the grade 4 to grade 3 petition. Grade 3. The petition
Grade 4 to grade 3.
Yes, my lord. And the item number 14, where the petitioner who was earlier approached this court for promotion because the junior person to them, he was already been promoted. This court has directed to consider the case, and thereafter the petitioner, non-compliance of the court order, petitioner filed a contempt petition. The petitioner is contempt petition, where the contempt petition was closed with an observation, that is annexure 10, page 27 of item number 14.
Twenty.
7, page 27, my lord.
Yes.
And may I read my lord?
Annexure 10.
Annexure
Yes,
10.
please read.
Whereas the Honorable Guwahati High Court by judgment and order dated 15/6/2011 passed in WPC number so and so, Bharat Chandra Borua versus State of Assam and others, has pleased to dispose of the instant petition with a direction to the Director of Health Service within bracket U means Udalguri, Assam, Hangrabari, Guwahati 36, and the Director of Health Service BTC Kokrajhar to pass an appropriate order in connection with the grievance of the petitioner within 3 months from the date of pronouncement of the order. Whereas the instant petitioner has claimed for promotion from grade 4 post to the post of vaccinator, which is a grade 3 post at per the respondent number 6, who is junior to the petitioner, and have got promotion from grade 4 post to get post the basic health worker, which is a grade 3 post under the Health and Family Department of Government of Assam thereof. Whereas the Government of Assam has pleased to create surveillance worker in abolish the post of vaccinator, and as per provision of Assam Vector-borne Disease Control Program Worker Service of Orders 2006, surveillance worker and basic health workers are non-gazetted class 3 service under the Government of Assam, and the recruitment to such service shall be made by only direct recruitment in accordance with the Order 6 of the aforesaid Order 2006. And therefore, in view of the fact and circumstance, the claim of the instant petitioner for direct promotion to the post of vaccination is not sustainable in the eye of law, therefore rejected. As regard to the promotion to the of respondent number 6 in the instant case, it is hereby directed to the Director of Health Service BTC Kokrajhar to cause step to inquire into the matter and submit a detailed report immediately in the light of the judgment and order passed so and so. But after this order, my lord, they have stated that the post of vaccinator was abolished, but that is not done, my lord, as because my lord,
if I have understood you correctly, earlier you had approached this court for consideration for promotion from grade 4 post to grade 3 post,
as he was the senior most.
Correct. Now there the court had directed that has disposed of with a direction to consider your grievance.
Yes.
Correct.
Yes.
Now in pursuant to the aforesaid direction of the Honorable Court, the government, the BTC has passed this speaking order.
Yes, my lord.
Whereby they have considered your case.
Yes.
But what have they? Because it says they are agreeable that the claim of the petitioner. No, they say it is not sustainable.
Not sustainable.
So they have rejected your claim.
Yes.
On what ground?
Saying that the post of vaccinator was abolished and the surveillance worker post is created, which is a grade 3 non-gazetted post.
Which is a grade 3.
Grade 3 non-gazetted post, and recruitment to the post is a direct recruitment. So, but that is not done. That is not true, my lord. Annexure 12, page 32, which is issued by the Director of Health Service on 2013, where the total number of vaccinator posts is shown that as 16 numbers. That the still vaccinator post is alive, my lord. And
what is the stand of the BTC?
we have filed your affidavit.
You filed your affidavit?
In this, not this case, subsequent.
No, in item 14 you have not filed. In 515 you have filed. And are you adopting the same affidavit here?
Yes.
You are appearing in both 14 and 15.
Yes, sir, both.
And what is the 50? In 15 you are.
In the meantime, my lord, there is a selection process was going on, and petitioner was both 3 of the petitioner was selected by the duly constituted selection committee for the post of grade 3, but that was not acted
This
upon.
council merely being selected doesn't mean appointment will be given.
Yes, my lord.
Appointment has to be given as per the rules.
Rules, my lord.
So
But
are
the-
you will have to bring out a case that you have been given a discriminatory treatment,
Yes.
or the rules have not been followed. Correct, because in item 14 you are challenging 1/3/2012 order. Correct.
Yes.
Now here it appears that the government has taken a decision. The government
But the-
says post of vaccinator is not it is already abolished.
Not abolished, my lord.
No, so Miss Bora, have you
No, my lord.
explained in
Still
the affidavit filed in item 15
Lordship.
as regards this position?
Yes,
Because you see, they have brought in one annexure at page 32 to show that 16 number of vaccinator post is existing
Yes,
as
still
on
exists.
13.
Lordship, but Lordship, earlier who were working in the
No,
vaccinator.
what I'm asking, Ms. Bora, is have you given your defense in the affidavit?
Yes,
Where?
that particular point not, but as a whole.
No,
we
if
have-
it is not there, Ms. Bora, you have to address that point. Are you understanding? Because if I'm taking up item 14, I don't know what is there in item 15. But as far item 14 is concerned, if we have correctly heard, the only argument coming forth is that the post of vaccinator has not been abolished as claimed by BTC, and in support of that, they are relying on this annexure 12. Correct? Now your response has to be there.
My
Now
lord,
that response has to be in writing.
not
So
in
if
the-
it is not there, then you take instruction and you file an
Then-
affidavit
then Lordship.
in item 14.
Okay.
Otherwise,
Lordship,
how can this court proceed?
Lordship.
Correct?
Then
You clarify that. As prayed for by Mr. R.B. Bora, right?
Yes.
R.B. Bora, Learned Steering Council, BTC, list this matter after 2 weeks on a date to be fixed by the registry to enable the respondent file return in the matter. I am using the word return only because I'm giving you the liberty. I'm not restricting it to only this point. So you file whatever you want to file. Ms. Sharma, you want to say something? But Ms. Bora, it is understood that you basically have to clarify that.
But that order was passed on 2011 and that post was identified.
Let them file their
Yes,
return,
sir.
because otherwise how will this court adjudicate?
The thing is that in 2013, they have stated the 16 numbers of post of vaccinators, they still exist.
So you clarify that. Should I say that in the order?
Lordship, I said,
Must have been.
And then 16.
But Your Lordship,
Yes.
in this case, I have some difficulty. I have a part matter.
No problem,
in court
Mr.
number 7.
Dasgupta. This court will accommodate you.
No, only thing I have prepared a notes below. Let this be in your file, Lordship file, and Your Lordship may kindly fix it.
I have heard this matter earlier.
No. Then there's a 2017 matter.
No, you said you have prepared a note and you also said you have some difficulty. So I am slightly confused. Are you insisting that we should go ahead with the hearing today, or are you seeking an accommodation?
An accommodation.
As prayed for by Mr. A. Dasgupta, Learned Senior Counsel, assisted by MS B. Das, Learned Counsel, list this matter again on
No, let it be on Tuesday next.
on such and such date.
Tuesday next.
All right.
Item 19.
Here in this matter, if your lordship peruses the order dated 4/8/21.
Yes, I have it in front of me.
Yes, that particular order, this writ petition, there is under writ petition. 382.
Petitioners were asked to be ready with records.
No, not petitioners. Basically, the affidavit filed in that 3828.
Where
government
is
relying
petitioner
on that.
today? No one is there. None appears for the petitioner when the matter is called. Mr. D. Bora, Learned Learned Junior Government Council, and Mr. S. Bothakur,
Yes, sir.
learned counsel for
For respondent number 4 to 10.
respondent number 4 to 10, and Mr. S. Doctor, learned counsel for respondent respondent revenue department are present. In view of non-appearance, on behalf of the petitioner, list this matter on Friday under order column with remark for dismissal.
Item 20.
In this matter, Mr. Dinath is appearing. Item number 20. Mr. Dinath is appearing. Perhaps he is on legs and some other court.
Petitioner is also not there. Man appears for the petitioner when the matter is called. List after 1 week on a date to be fixed by the registry.
Item 25.
The petitioner was appointed as an artist.
Just one sec. ইয়াৰ আগৰটো যে কালি ফিক্স কৰিলাম সেইটো কালি নালাগে লিষ্ট অফ সেইটো দিব নালাগে ডিসমিসল কলমটো নালাগে after 1 week on a date to be fixed. Yes.
Lordship, the petitioner was appointed as an artist in the pathology.
Artist?
Yes, Lordship, in the pathology department.
Health?
Lordship, my friend was here a few minutes back.
Mr. Fukan, you are getting hold of someone?
Lordship, he joined in 2/1/1996 and he was continuing his services as such, Lordship. Then in 16/9/2020, he came across an order whereby he was transferred to pulmonary department.
To what department?
Pulmonary department, wherein he was assigned duties as an office assistant, Lordship.
Office assistant?
Yes, Lordship.
So it's a reversion. He has been
not exactly, but they say that due to COVID-19 pandemic, there were shortages of persons in that department, and due to that, Lordship, that was required to be done.
What is the prayer?
Lordship, now the pay scale of both these posts are different, and there are these posts are still lying vacant. And
so you are now reverted to a post which has a lower scale?
Yes, Lordship.
Huh? You have been, is it?
Yes.
Scale is same.
It's not same, Lordship. Lordship may kindly see.
You see, because if that is so, then prima facie it appears it cannot be done.
Cannot be done.
So show me, first you show me what is the post that you were initially holding, what is the pay scale, and now where have you been sent and what is the pay scale. These are the two things you need to show.
Yes,
so show it.
Lordship, the pay scale, it's at paragraph 2, Lordship.
Paragraph
2, page 3. May I read it, Lordship?
Yes.
That the petitioner begs to state that he came to be appointed as an artist in the Department of Pathology, Guwahati Medical College by order number so and so dated 2/1/1996.
All right, this is pay scale is 1285, 30, 1435, 40, and like till 3075.
3075.
Correct?
Yes, Lord.
And he joined on 2/1/96. Then
Lordship, next 2, page 12, Lordship.
Page?
Lordship may kindly turn to page 11 once, Lordship.
Page 11.
The third paragraph, Lordship.
Yes.
Until further orders, Sri Hiten Pathak Artist, Department of Pathology, Guwahati Medical College, Guwahati, is hereby directed to do his duty as office assistant to the Department of
Pulmonary. Yes.
Now, Lordship,
what is the pay scale of this?
The pay scale, I have raised an issue in my representation, Lordship, page 14, paragraph 5. Herein I have clearly stated that the pay scales are different, Lordship.
No, but how have you shown? What is the stand of the government? Is it same?
They have not said anything with regard to that. They have just said that
your representation has page 14.
Page 14, paragraph 5, Lordship.
Yes, you are saying the requisite education qualification, lesser pay scale. Yes, what is your stand?
Lordship, as per, I have filed my affidavit, Lordship.
Yes.
In para 9, page number 3. In
Para
my
9?
affidavit. Para 9, page number
Yes.
3 of my affidavit. As per Honorable Court's order,
There was a court
dated-
order.
Yes, Lordship.
8321
Yes.
and the representation of the petitioner. The petitioner is presently posted.
Let us see, where is the High Court's order 8321?
8321.
In this case itself, Lordship. In this case itself, Lordship.
8321.
What does it say?
Lordship, I was required in the meantime to be posted in Guwahati Medical College, Lordship.
That's the order.
There was subsequent development, Lordship, when he preferred a representation seeking posting to the post of artist. They released him from service from here, Lordship, and he was.
So there was an interim order to not to give effect.
Yes, Lordship. As per that, he was again posted.
No, Ms.
Pulmonary
Counsel, you
Medicine
see,
Department.
let us confine ourselves to the basic issue that is involved in the proceeding, right? All that now you need to show me is the pay scale is similar. If it's same, because they are saying they have
As
been.
per my verbal
No,
instruction,
that verbal will not
yes,
do.
Yes, Lordship.
You see, because even the petitioner is not showing. Petitioner have, however, on oath, they
Yes.
have said that it is a lesser pay scale. Now, if that be correct, then that cannot be allowed to be done.
Yes.
Correct. So now you have to show me the pay scale of the post of pulmonary medicine department. That's all I think.
Yes.
Yes, Lordship. And subsequently, they have issued a certificate, Lordship, wherein there was a break in service, Lordship, that was shown, Lordship. So, how that had occurred and why they had made that break, Lordship? Because I was attending my duties regularly.
So for that, you have filed a reply
Yes, Lordship.
to that effect.
Yes.
That is the second point. But you see, even if that be so, they can't revert you to a post with lesser pay scale without giving you a show cause notice and an explanation.
Yes,
if that is the reason that you have been posted to the post having a lesser pay,
Yes.
Yes,
this has to be done as per the procedure of law. It cannot be done as per the whims and caprice of a respondent officer.
Lordship.
Right. So first and foremost that is required to be seen is what is the pay scale.
Pay scale, Lordship.
Heard Mr.
I am MP Sharma.
MP Sharma, Land Counsel for the petitioner, also heard MS
D. Bora.
A. Bora.
D. Bora.
D. Bora, sorry. D. Bora, Learned Standing Counsel,
Health
Health.
Department.
So, during the course of the hearing, it appears that the issue involved in this writ petition is the issue involved in this writ petition is that the petitioner who was holding the post of artist has been reverted to a post, to the post of, what is the post
Office
called?
assistant.
Office assistant
in the
in pulmonary medicine department, GM,
Guwahati Medical College.
GMCH.
It's in GMC only, Lordship.
GMC.
Hospital is different.
GMC. GMC, which carries lesser pay scale than the post of artist, which the petitioner was initially holding. Stop.
In the Department of Pathology.
Yes.
Which is pathology?
Artist in
Artist
in pathology.
in the Department of Pathology. In the affidavit in opposition filed by the respondent authorities, the respondent has not addressed the said issue regarding the pay scale of both the posts in question. MS so and so, learned so and so seeks 2 weeks time to file an additional affidavit to clarify the pay scales of both the posts. That only you need to clarify.
Lordship, and one more thing, Lordship. I've been told that that post is still lying vacant, that post of artist. And
All that I'm not going.
There is no reason as to why they cannot send me there.
It is for Mr. So-and-so further submits that the post of artist in pathology department from which the petitioner was reverted is still lying vacant. Let instruction in this regard also be obtained and placed by way of the affidavit proposed to be filed by MS so-and-so, Lalit so-and-so. List again after
3 weeks, Lordship.
3 weeks and a date to be fixed by the registry.
I'm obliged, Lordship.
Obliged.
Item 26.
Three weeks.
Departmental proceeding matter, Lordship, penalty of reduction of pay, Lordship was imposed, Lordship. Departmental proceeding matter, Lordship, penalty of reduction of lowers is imposed, Lordship.
None appears for the petitioner when none appears for the petitioner when the matter is called. List after 2 weeks and a date to be fixed by the registry.
My presence may be
Mr.
N.K. Sharma.
N.K. Sharma, learned counsel for the respondent number 2 and 3, and Mr. D. Bora, learned government advocate for the state, are present.
Respondent number 1.
Within bracket R1.
Supplementary hearing 30 and 31.
Change it.
My lord, these two matters are against an award passed by the Labour Court. So for 30 is concerned filed by the workman, 31 by the management.
30 is by the workman.
And 31 is the management.
This is a Labour Court award.
Award.
So what is challenged? The proceeding of the
In
tribunal?
item number, my lord, 31, we have challenged only a portion of the award which your lordship will find. Lordship may have
A reference was, is a dismissal?
No, it was a case where the workman was retired from service. Now his case is that it was a premature retirement. He should not have been retired at that point of time. So a reference was made. An award was passed. Labour Court held everything. Management was justified in retiring. But having come to that conclusion, Lordship will have a look at page 90.
Page
90 of item number 31.
6540.
2996. 31. Page number 90 is the award by which the management is before your Lordship being agreed.
Page number
90.
19.
90. Paragraph 18. I am of the view that the delinquent employees, so and so, is not entitled to reinstatement in his service with full back wages and other consequential benefits and so on. Now then, the part which the management is aggrieved. The management is a local authority. The terms and conditions of the employment of the employees are governed by statute and statutory rules. Similarly, the retirement of the employees is also governed by such statute and statutory rules. There was no domestic inquiry held, though it is the most important one in case of any dispute between the employer and the employee. Knowing well that the employees are weaker party in the industrial relation, thus it is utmost important for the employers to carry out the inquiries in accordance with the principle of natural justice. It reveals from the record there was no domestic inquiry held in connection with the instant case.
This was not a termination.
Exactly. That is the part by
if I have understood you correctly, they had asked for a retirement.
Yes. According to the record of the garden, that man has attained the age of
superannuation. And accordingly, he was retired.
From service.
But then a dispute was raised by the workman that he has been wrongfully retired. Correct? If I've understood you correctly, that is the. Let us see whether terms of references. The entire award is put to challenge by Mr. Chakraborty.
Both the sides. They have
But you are aggrieved by the entire award. I don't think Mr. Chakraborty is.
We are aggrieved by that part of the award
where you are saying that an inquiry,
and we are directed to pay 1 lakh as compensation.
Though the court have said that you are not entitled for reinstatement, however, the tribunal have said that an employee cannot be
without any inquiry.
Yes, natural justice. But in the case of retirement, what inquiry?
Lordship, my case is solely based on the Assam plantation labor rules.
Okay, before coming to that, since I'm taking it up for hearing, you can
My
go slow.
My lord.
Let me first understand the reference. Where
Lord.
do I get the reference?
Page 79 of
Let him submit. You both are now appellants, so one can do it. Yes, so I'm taking 2996 first.
Yes. Now is the page 79
Yes.
is the award page 79. The issues are recorded, my lord. Whether number one,
Just one second, sir. Yes, Mr. Patwari, where is Mr. Borpujari?
Nowhere to be seen.
Huh?
Is nowhere to be seen. Maybe
Please, because you see, I am now starting another hearing, but it would have been appropriate if I finish the part heard first and take this up.
Yes,
So
definitely.
try and find out, because at 2 also there is another matter. Yes, sir. You give it again, otherwise I will dispose of that petition.
I'll go and see.
Yes.
page 79, the issues are: one, whether the management of Bogapani Tea Estate is justified in making premature retirement of Mangra Etwa a substaff with effect from so-and-so instead of so-and-so. And whether the date of birth of the workman so-and-so is 1154 or 24/6/1968. Whether the workman so-and-so is entitled to reinstatement in his service since 31/12/2012 with full back wages, and what relief the parties are entitled to.
So according to them, if the date of birth is taken as 24/6/1968, then the retirement should have been 23/8/26.
Yes.
But instead, it is now he has been retired on 31/12/2012. So therefore, the dispute is about the premature retirement. This is their dispute.
Now, my lord, the learned labor court has come to a finding that the workman is not entitled to any reinstatement.
What about the date of birth and the retirement age? What is the finding of the labor court to that?
That the date of birth, that workman was not retired prematurely.
That there is a clear finding.
Yes, ma'am.
Where is that?
My lord may come to page 89, paragraph 16. I have
Because
carefully...
Mr. Chakraborty, if that is the finding, then there is no question of giving any notice.
Inquiry.
Yes.
My lord, what domestic inquiry? If I have understood the word domestic inquiry, the domestic inquiry is in relation to any misconduct where charge is alleged.
Correct. This is what even this court, subject to correction, understands the same.
So,
domestic inquiry is in relation to some
allegation of misconduct,
allegations,
where a charge sheet is framed and inquiry is conducted.
For retirement, domestic inquiry
No,
is not
no.
required.
And then, my lord,
Unless, of course, you see, there could be because if what the workman is saying, that his date of birth has been wrongly taken, for which he has been prematurely retired. Now that is a dispute that has been raised, and that itself, the factum of that is only under reference.
Yes.
So now there has to be evidence adduced by both the parties to that effect. There has to be a clear finding based on the evidence either way.
Yes.
Now, if the finding is that the retirement is correct, nothing more is required to be done. If
so
the
for a
finding
moment,
is,
Lordship may have a look at paragraph 16.
Paragraph
16, page 89.
Yes.
I have carefully shifted the evidence on record. Considering the evidence on record, submissions of the learned counsel of both the parties and reliance of the decision, I hold that the management of Bogapani Tea Estate was justified. Retired the workman so-and-so on his superannuation.
No, that is all right. This is the finding. But on what basis?
My lord?
Where the court has discussed how the court has arrived to this finding. Are you following what I'm saying?
Yes. Yes.
I understand I'm exercising 227 here. Is it 227 or certiorari?
226.
Certiorari.
Yes.
But the court to come to this finding that you are justified in retiring, what is the material?
Now, during the course of evidence, before I take your lordship to that part, during the course of evidence, we have exhibited his PF form, which was duly signed by him, wherein his date of birth is recorded. Now, my lord, his case, the workman's case, is that it is wrong because during the course of a trial, he produced one school certificate. Now, my lord, at any point of time during his service period, even on receiving the notice of retirement, he has not raised any dispute with the management that it is wrong. It will be recorded. Now, before I take your lordship to the award, just certain basic facts, lordship. Lordship, workman was appointed in the year 1986. Lordship may come to page 26 of the writ petition.
Page
26, it is the nomination form which is exhibited in the inquiry. It is not in dispute. Lordship will see the name of the workman, Mangra. The names are very important. That is why I request your lordship to just note down the names. Mangra Etwa.
One sec. I'm sorry. Which page?
Page number 26 of the writ petition filed by the management.
26.
It is the nomination of PF form.
Yes.
Here the name is Mangra Etwa, son of Etwa Bango. Name Mangra, M-A-N-G-R-A, Etwa. Father's name Etwa Bango. Date of birth 1/1/1954. Joined the fund on 21/1/1954. And at the bottom, lordship will see that it is his signature, which he admits during the course of trial that he
Where bottom?
Bottom of that form.
Say status of signatory.
Yes, signature. Yes.
LT at this time.
Yes, Mangra Etwa.
And this is a nomination form.
Yes, that is the PF record.
PF
record.
Yeah.
Now, it is an admitted position, and he has not denied that it is not his signature. It has come on record. Now, my lord will see the transfer certificate which he is relying, the petitioner, which is at page 44. This is the document on the basis of which the workman is claiming that his date of birth is wrongly recorded. Lordship will find at page 44 certified that Bango Munda.
Yes.
Certified that Bango Munda.
The name is different.
Yes. Mangra Etwa.
Mangra Etwa. And this is Bango
Bango Munda. Father's name, son of Etwa Munda. And on the basis.
And the other one was Etwa Banga or something.
My lord, Etwa Bango.
Bango.
Workman in service, Mangra Etwa, son of Etwa Bango. And here it is Bango Munda, Etwa Munda.
And the workman name otherwise is Manga Etwa.
Mangra Etwa, everywhere. Lordship may have a look at his appointment letter.
Yes. Here his date of birth is shown as 24/8/1968.
Yes. So his
now
appointment letter, page 23 is a promotion. It is not the initial appointment, but
Mangra Etwa.
Mangra Etwa. In the written statement or the dispute raised before the court, this workman, lordship may come to his application before the labor court at page 38. I'm sorry, my lord, page 36 is the application before the labor court.
Mangra
Etwa, verified as Mangra Etwa, son of Etwa Bango.
Page 41.
Page 41.
And his signature is also Mangra Etwa.
Yes, everywhere it is Mangra Etwa, but the certificate which is relying.
That is somebody else. Appears to be
somebody.
In any of the affidavits he has signed as that Bango Munda.
No. And it has come on record. I will take your lordship to that part. Lordship may give me a moment where he admits that everywhere it is Mangra Etwa, but it is only in the school certificate where he is.
How can that be, Mr. Chakraborty?
Let him finish, Lordship, if he has finished. Lordship.
No, but if that is first and foremost, one needs to clarify.
Lordship, I have submitted an affidavit to them.
Where? Let us, because that is the whole
Page,
issue.
page 45. Page
Page?
45. Page 45.
What is this affidavit?
Now, in this affidavit, Lordship
This
will-
is an affidavit
by
of
Mangra
20
Etwa, son of Etwa Munda. He is saying that Bango Munda and Mangra Etwa is one and the same person.
This is your own affidavit. Now,
Now-
your father's name cannot be also different.
Yes, exactly. Lordship has got it right.
Let him complete, Lordship.
Now, my lord, my lord has seen, he is saying Mangra Etwa, son of Etwa Munda. So, Mangra Etwa and Bango Munda may be the same person. But one is Bangro Munda, son of Etwa Munda, and in the certificate it is different, my lord. Father's name is different. The affidavit does not say that his father is one and the same. In the certificate at page 44, it is Etwa Munda. Now the question comes, my lord, two things. One, whether this certificate can at all be relied, whether it is a clinching evidence to show that it was wrong. Because it is the burden is heavily lying on the workman to show that whatever it is recorded in the garden is incorrect. So 1154 we have justified this is something which we have. It shows here your date of birth is 1154. And you admit that yes, this is my signature.
And he bears, where does he admit that it is his signature?
My lord, it has come. Page 66 may kindly, page 66.
The objection was raised immediately after the termination, or
After, yes.
Immediately.
Immediately on his retirement.
Upon issue of the notice.
And Lordship will see the notice of retirement was issued on my lord 31/12/2012.
31?
Notice of retirement says that he will be retiring on 31/12/2012.
This affidavit that you just showed.
Yes, my lord. Lordship may
what is
come
that
to
date affidavit? 2011. 12.
my lord. Which affidavit?
His name.
22/11/2012.
20.
20.
No, I think 2011.
2011/2012.
12.
Now-
Before the notice, after the notice. No, before the
the notice. I do not know whether why or under what circumstances, but the certificate was issued
surprisingly very near.
very near.
Very near to
And this school certificate was issued sometime on 2010/2012. Just at least 2 months before the
which school?
page 44, the certificate, the school
Yes.
transfer certificate.
2010.
2010/2012,
These
whereas it is shown that he left the school on 36/81. A person leaving the school in 81.
This looks very.
Even my lord, assuming this.
When did he leave?
1981.
Yes, I got that date.
Now, my lord, lordship is aware. I need not trouble your lordship by setting cases that this is the certificate issued by school authority. Even to prove this certificate, the school authority, the headmaster, and the record of the school ought to have been.
Where is that admission?
My lord, may come to page 66.
Yes.
I'm reading the second paragraph.
It is not a
fact
fact.
that Bango Munda and Mangra Etwa is not the same person. I left the school in the year 1981, but I have procured the school certificate in the year 2012. I collected certificate after receipt of notice of retirement from the management of the tea estate. I worked 26 years in the tea garden. During those periods, I did not submit any document in relation to my age, nor I filed an application for correction of my date of birth. It is not a fact the school certificate is not belonging to me, but I fraudulently so and so. My name is Bango Munda. My name as Bango Munda had been recorded in school only, but not in any other institution or organization. So Mangra Etwa, who is an employee, he is saying that his name as Bango Munda is
This I've
recorded.
understood, but where have you said that he has admitted that signature
My lord.
appearing in the PF nomination
Yes,
form?
then Lordship may skip the line starting from Exhibit D.
Yes.
Exhibit D is the PF nomination form which was duly signed by me.
Which is duly signed by me, yes.
In PF nomination form, my date of birth is recorded as 1154. Exhibit D does not disclose on which date it was prepared. Generally, a PF norm has been prepared at the time of joining in service and
So
according to
this
the.
he agrees.
Now, my lord, the workman in the writ petition, this case is that we have failed to establish his date of birth by bringing the leave as required under the Assam Plantation Labor Act, that is leave register and other things. Now, my lord, assuming we have not produced, we have produced one document, which PF form. It says it is 1154. It contains the signature of the workman.
Where is the notice of the
retirement? My lord, may come to page 26.
I'm wondering, since you both are appellants, who will give the last reply?
No, so far, my lord, our writ petition is concerned, we are aggrieved by that part.
Understood. That I have understood.
That domestic inquiry and direction of 1 lakh. My lord, page 30, my lord.
Yes.
It is the date is not there as you have attained the age of retirement, which is 58 years above your service.
This
the
is
company.
a typed copy.
Yes, my lord. It is a typed copy, but there also, my lord, the date is not there.
Again, this a representation was made.
Now he has admitted that I have come.
That I have seen. But,
that we have not during. No.
Because it is, he has admitted that after getting this notice, he has obtained the
School
certificate.
And after this retirement notice, he did not
How
file
come there
anything.
is no date here?
My lord, this is. But the fact that he has retired on. This
No,
is
you
his
see,
retirement.
the notice of retirement
My
has
lord,
some
yes.
relevance.
Ought to have been some date.
Has some relevance because you see, in the year 2000, near about that time, two things have been done by the workman. Number one, he has collected his school birth certificate. Number two, he has filed, he has executed an affidavit wherein he says that these both the names are of one person.
But in even assuming for a moment without
No,
admitting.
You see, if these are done after the notice, your case becomes much more stronger.
Since
Because-
the date is not given, my lord.
Correct, but your records you should have
Yes,
checked.
that I agree, my lord. But it is not in dispute that no notice of retirement was given, and this 31/12/2012 is the date of his superannuation. It is the case of both
Sometimes
the
these management, I feel they just do
Yes.
things in a very
whimsically,
casually
casually,
How
without
come
knowing
the
the
notice of
consequence.
retirement does not carry any date? It should have carried.
Yes.
But nonetheless, it appears it was done prior to 2010-12.
Yes, because he admits that he collected the certificate.
So
after.
if that be so, the affidavit is of 2011-12.
Yes, after that. Even, my lord, from that affidavit, what is stating on oath is that Mangra Etwa and
anyway,
yes, it's the same person, but the
anything
father's
more?
name still appears to be different, even in the affidavit.
So
And
these things the labor court has gone into,
yes, my
has
lord.
taken note of.
Yes.
Yes.
Now, in page number 85, the Learned Labor Code is recording the evidence of MW1.
Page number
85. See, Kamaldeep Singh MW1 has stated in his evidence that he is an assistant manager of so-and-so. He joined the company. In the Sri Mangra Etwa was the substaff of Bogabani Tea Estate. He joined the company on 21/3/1986, and in his PF nomination form, his date of birth is so-and-so. As per the company's norms, the retirement age is 58 years. and accordingly, Mangra Etwa attained the age of retirement on 31/12/2012. The management issued notice to Mangra Etwa that he has retired on so and so. Exhibit A is the retirement. So, in his entire service career, Mangra Etwa never challenged his date of birth. And at the end of his career, he is producing one school certificate which is in the name of Bango Munda, not in the name of Mangra Etwa. The workman in his entire service career did not even mention that his name is Bango Munda, nor he produced any other document in that name. So, my lord, it is a case where the workman failed to at least prove that whatever is recorded is wrong. Now, Lordship is aware there are numerous decisions which says that date of birth cannot be rectified at the fag end.
Again.
Now,
Burn standard, I think there was one case.
My lord,
Burn standards.
there are many, my lord. I just got
Yes,
one.
there are
many, but I got only one decision, my lord.
But you see, here this is not a case where they are seeking correction of date of birth.
Yes,
That
they
is
are
not
not
the
seeking.
case.
Yes, even they are not seeking. They have not approached the management. But on the contrary,
no. But what is the date of birth that is recorded in the register? Have you
register
produced the
we have,
register?
we have the PF register.
Is that the date of birth? Because there must be another. There has to be a register in the office records belonging to the employee concerned, where his date of birth has to be recorded.
They have these two documents which were exhibited. One is the PF nomination form, and another is census checklist where everything is mentioned. Now, my lord, the case of the workman is agreed. He has raised a dispute. We have produced some materials, evidence to show that according to the garden, we have this is what we have. Now, to rebut this, some clinching evidence ought to have been placed. Now, in this judgment, my lord may come to.
Just give me the paragraph.
Yes, my lord. Where
plantation কিবা act এখন কৰিছে ন এখন correct হল লাগিব please give the reference of that
local acts লাগিব local action rules Assam plantation level rules.
Lordship, in this case, the Honorable Supreme Court in paragraph 10 has laid down what is required to be done. Considering the aforesaid decisions of this court, the law on change of date of birth can be summarized as under. Application for change of date of birth can only
how is it relevant?
My lord?
How is it relevant? Because these are change of application for change of birth, date of birth.
Yes.
That is not the situation here.
Yes,
They have
but even his case before the labor court is that his date of birth ought to have been 68, and in support of that, he has submitted a certificate. Now,
but has he applied for correction?
No, he has not
Then
applied. Now, here it says
this is for correction. Paragraph
10, even if there is
Paragraph 8.
Paragraph 10,
10.
page number 18, but the law can be summarized. Application for date of birth can only be as per the relevant rules and regulations. Even if there is cogent evidence, the same cannot be claimed as a matter of right. Application can be rejected on the ground of delay and laches, also more particularly when it is made at the fag end.
You are trying to borrow the ratio of correction of birth,
Yes.
date of birth. We can see, but otherwise this is not on
Yes,
this point.
not, yes.
Here, you have to show that as per your office record, this is the date of birth.
Yes.
And if the court comes to a finding that that is correct, then subsequent retirement, you don't need any notice or anything.
Yes.
But suppose the court comes to a finding that there are cogent materials which the other side have placed showing that the date of birth was different, then of course it could be a different situation.
But that did not happen. They, apart
So it
from
all depends on the
nature of evidence.
weight of the
Evidence.
evidence that has been adduced.
Nomination form shows 1154 and two
Because prima facie it appears that that school birth certificate belongs to someone else. It can't be that his father is also two different persons.
two different names.
Father, that is not inspiring the confidence of
Yes,
this
my lord.
court.
And-
Then I have to see how the court, labor
Yes.
court has done it, because here Now, I think the only question, the only question that I am concerned is about the error of law.
Yes.
Correct.
Now here the labor court has recorded everything, says that no, management is justified. Now if the management is justified,
Then we are right.
then we are.
If that is the finding of the labor court, then of course the subsequent direction doesn't appears to be perverse.
Mile.
There is no requirement for giving any notice.
Yes. That is what the management's writ petition is all about. Now the workman has filed a writ petition challenging the entire thing. Well, his case
So
is,
let me hear.
yes,
Mr.
I will give a
Chakravarti.
reply to his argument.
You want to proceed in this writ petition, or should I take 6540?
Lordship may take my petition. Lordship. That will be the reply to his.
Mr. Bor Pujari, you become free from all courts? All right. Yes.
Lordship has seen this, the notice is without any date. No, Lordship.
Yes, notice doesn't bear a date.
Doesn't bear any date, Lordship.
But one thing is there, from your evidence it appears you have received this notice before you went to collect your school certificate.
Lordship. Now, Lordship may come to page 37.
Page
37. That is the evidence I submitted before the lab.
37.
37. Paragraph number 2. This is top, Lordship. Page 37.
Yes.
I have stated, Lordship, the PF nomination form, 2 pages of form number 3 filed by OP go to show my date of birth is 1/1/1951. It is not true and it is wrongly recorded by management. First of all, they took my signature on blank form with the gratuity form number so and so, and they did not maintain my service book in accordance with my. So, Lordship, I have stated so. That was obtained blank. Lordship.
This was stated where?
In evidence.
In your evidence.
Evidence, Lordship. So no cross on this regard, Lordship. That blank part was not received. That there is no suggestion to that regard, Lordship.
Yes.
Now, if your Lordship comes to the cross of MW1, Lordship, page 45.
Page
45.
Yes.
One, two, three, four, five, six. The 6th line, Lordship.
Yes.
I have not submitted in the court the copy of workers registered in which all biodatas of the workers are recorded.
This was what I was asking.
If this could have produced, Lordship, my case would have gone, Lordship. It is mandatory to keep such record in every state. So where is that, Lordship? What they have produced, Lordship, further, Lordship, page 46.
They have produced some census checklist.
Census checklist, whether there's a valid document to prove age, Lordship, and the nomination form. That has been
Mr.
relied. That is
Chakravarti,
without any date.
I understand what you are saying, but
whether they are required to keep that or not,
no,
as per the Assam Plantation Revenue
that
rules.
today we have to keep.
Lordship,
Correct?
76.
Now,
Rule 76, Lordship.
It appears, nonetheless, they have come up with some PF nomination.
Whether that will be valid.
Now, there it appears that you have already signed,
Lordship.
and you have put the date and father's name.
I've in my evidence.
Now, in subsequent, in fact, your own verification, also you have written the same name and same father's name. Correct? There is no dispute to that.
Dispute to that.
In your own evidence before the labor court, you have said that you have signed. Now, in that, you have not said that your signature was falsely taken or forcefully taken.
But I have said it in blank paper.
That you have come up only at the evidence,
Lordship.
first time.
But there is
Prior
no cross
to that, you have never raised this objection. But assuming you are correct, you could have taken up that stand.
Lordship.
Right? You have not taken up that stand.
Lordship.
Now that is one. Second, it appears that that school certificate has some other name.
Leaving that apart.
Now,
Yes, I could not prove.
Now, correct. Now, if
For
that is
assuming
not true,
I
if
could
that
not
is
prove my
not
case.
true, then before the court, at least one document is on record that PF nomination.
Lordship,
which
I'm coming straight to that, Lordship.
Yes.
Page 67.
Page 67. Yes.
This is without any date. Bottom, Lordship, left hand side. Again, Lordship, the members' caste or surname, Munda, that is there, Lordship. That my caste is Munda. That is there, Lordship.
Sorry, I didn't get it. Members' caste or surname, Munda.
Munda. So my sometimes I use Munda. That has been admitted by their own.
What about your father's name?
MW2, Lordship.
What about your father's name?
Lordship, may kindly come to page 50, Lordship.
Page
50.
50.
50 is a cross of management witness number 2. The first line, Lordship. The daughter or son of a particular person may not use right their father's
That's
surname
okay,
as
but
their
what about
surname.
the father's name?
Lordship, sometimes they use it happens in the
father's
now,
name.
Lordship, one interesting fact. Every member of my family was born on 1st of January. Lordship, that is what they have census checklist say, Lordship. This is, Lordship, will find at page.
But how can this court go on all this?
Lordship, that has
so
to
that
be-
is why you see, neither of you are taking me to the the evidences
So
which
it's
the
a case-
Labour Court has discussed. I
I'll take. I told you.
Yes,
I'll
I
take
want
your
to see
Lordship.
that because let us see how the Labour Court has come to that.
Lordship, I can say page 68. This
Page-
is the census checklist which they have relied. Page 68.
Yes.
My family name will, Lordship, find in the second. First one is Ladro Birsa
Yes,
family,
Mangra Etwa.
then Mangra Etwa family. Everybody is born on 1st of January, Lordship. Lordship, see the date of birth. And in this list, Lordship, there are altogether 31 persons' name. Out of that, 16 were born on 1st of January. Would it be possible, Lordship? And my I have annexed the birth certificate of my daughters, both daughters, higher secondary school, the SEBA given by SEBA. There's a different date, Lordship.
All right, Labour Court judgment. Let's see.
Let us go to Labour Court.
Let us have it from the first 2996. Since this court has already made some marking in that judgment, you can take me to that judgment itself.
Lordship.
I think it started page 78.
Lordship may come to
Before that,
I may refer the para, Lordship.
No. Before that, which is the provision that you are relying from Assam plantation?
Rule 76. Rule 76.
Registers.
76 registers.
Why the register was not produced?
My lord,
Because
yes.
register itself is the main document which proves why unnecessarily to rely a PF nomination form, which is also controversial. What about your register? What is the date of birth recorded in your register?
That was, of course, not. But I'd like to submit one thing, my lord. If my friend or the workman was relying that, yes, the PF that date of birth in PF nomination and the date of birth in the register may be different, what prevented them from filing an application for calling for the record? Had they called for the record, so my lord, an adverse inference can be drawn only when an attempt is made by the other side and that was not produced. So that is no, so whatever my friend is suggesting now, it is not part of the pleadings and the argument in the Labour Court.
All right. Yes, award.
Lordship, Lordship is done for the Rule 76 and the form also, Lordship. Form I have annexed to my writ petition. Form I have annexed to my writ petition.
Yes, page?
Page 73. The last page. Register of adult workers. Form 8. Lordship, the second one. Name, age, and address. If this could have been produced.
Now award.
Now award, Lordship. Page, Lordship, paragraph 12. The page may be different. The second, not the first part, the second, in the second page, Lordship.
Page?
Paragraph 12, the page number maybe, in my petition it is 59.
Okay, paragraph 12.
Paragraph 12.
Yes.
It starts from in Exhibit D.
Paragraph 12.
12. 1, 2, 3, 4, 5,
In his
6,
cross-examination.
7, Lordship, 7. The 8th line from the top at page 59. Start with in Exhibit D.
I'm sorry, I don't think
Page 59 of my red petition. Page 59 of
No, I'm now holding the award.
Award is award.
Which paragraph?
Paragraph 12, Lordship.
Paragraph 12.
Start from page internal
All right,
page
I
8.
got it. In Exhibit D.
In Exhibit D. In Exhibit D, it is not shown on which date it was filled up. PF number is also not shown. The management has not submitted the appointment letter of the workman. The leave book has also not been submitted in the court. The management has not furnished the Form 11 to the workman. MW1 has further denied of wrongly recording data. So all these three has not been produced before the court. That is, the court has himself has recorded. Then Lordship, paragraph number 14, page 60. May I read, Lordship? The fifth line, Lordship, start with appointment letter, Lordship. Appointment letter, medical certificate, nomination form, PF form are recorded and kept in proper file. At the time of appointment, they generally accept the school certificate in support of the age of the employee. In the absence of birth certificate, when the workman was born in the T hospital, the attending doctor of the T state issue birth certificate. So any of the document they could have produced, Lordship. This medical appointment letter or medical certificate, nominate form, nothing has been produced, Lordship.
Come to 15.
Paragraph 15, Lordship.
Read from the beginning.
Lordship, I have also heard argument both sides. The Land Council, by arguing for and on behalf of the workman, has submitted that Mangra Atwa and Bango Munda are the one and same person. And in this connection, the workman has already submitted his school living certificate, Exhibit 1. He has also filed an affidavit in this connection stating that his date of birth is so and so and so and so. And therefore, he should be retired on so and so, and prayed to set aside the notice of retirement, and also reinstate the workman with full back wages and consequential benefit. On the other hand, the Land Council, while arguing for and on behalf of the management of Bagapani Tea State, has submitted that Bango Munda and Zetra are not the same person. He submitted the false school living certificate and affidavit in connection with his date of birth. The date of birth is Manga Atwa is 1150 as per the official record of the tea garden and as per the PF nomination form duly signed by the workman Sri Manga Atwa. In census checklist, the workman date of birth is mentioned is 1154, which is a computer generated document. The Land Council for the management has further submitted that in every document the workman has mentioned his name as Manga Atwa. So Lordship has the Land Labour Court has relied on the census checklist and the PF nomination.
Yes, let's go on. Continue reading.
The workman made his affidavit and so and so after getting the notice of the retirement. At the end of his career, the workman is challenging his date of birth, which is not acceptable. In all official paper, he has signed and mentioned his name as Mangra Atwa and not Bango Munda. In the initial petition filed by the workman name is mentioned as Mangra Atwa and not Bango Munda. He has not even mentioned the original petition of Sri Mangra Atwa and Bango Munda is the one of the same person. In his voter ID card, his name is mentioned as Mangra Atwa and not Bango Munda. So, Lordship, in this regard, Lordship, I have my submission.
Yes,
yes,
Mr. Chakravarti, I understand your
Munda
submission.
is my family clan.
Yes, I have
name.
understood your submission, but let us continue reading.
Lordship.
Because this is the award is under challenge.
Lordship.
So let us understand how the award has been issued. I have appreciated both the arguments made by both of you.
Lordship.
But I'm just trying to understand on what basis the findings have been arrived. So this paragraph is important.
Lordship,
Let's complete.
In his voter ID card, his name is mentioned as Mangra Atwa and not Bango Munda. The Land Council for the management has submitted the school living certificate submitted by the workman is of someone else. The workman is trying to mislead the court by producing a wrong school certificate. If at all this date of birth was wrongly entered in office record, then why the workman did not correct it within 3 years from his appointment? The workman is not entitled for any back wages. The risk paid is free. For the Land Council for the management in support of his contention plays reliance on of the case in so and so so and so. Paragraph 13 of the paragraph 13. While the HSLC certificate can be an acceptable document for rectification of the date of birth of an employee, the representation or rectification cannot be concerned on the eve of retirements held by in the so-and-so case reported in so-and-so. It is well settled. The application for correction of date of birth can be entertained at the fag end of the care service period reported in so-and-so. So, Lordship, so what the labor creditors relied on the PF form and the census checklist, those cannot
Anything
be
else
acceptable.
apart from whatever
My
you have
case
argued?
is that it should ought to
No,
have
I've
been
understood.
proved by under the
Anything
plantation
else?
level.
Anything else?
Lordship. That's all, Lordship.
You
Under
are saying that the
it should have been proved by under,
according to you, management ought have produced the register.
under some plantation level.
Have you ever made this objection in any of your
No, that is, Lordship,
meetings?
that, this being the Bible
No,
in
I am
case.
asking.
Lordship.
I'm asking, have you ever raised this in
No,
the
Lordship.
pleadings before
Section
the
3
Labour
of the
Court?
Evidence Act. Prove what is proved and what is not proved. If that has not been done,
See,
because this is the Bible, Lordship.
What is the reference? Let's come back to the reference. Whether the management of Borapani TS is justified in making premature retirement as so-and-so with effect from so-and-so and so-and-so.
So, Lordship, to prove that
So the issue
my
number
lord,
one.
Perhaps, my lord, Lordship, I'll just rectify
Mr.
one thing.
Chakravarti, if the issue number one is as it stands under the reference.
It is not a reference, my lord.
this
It
is
not-
issue frame.
My lord, this is an
This is not a reference case. This
under
is,
2A.
Oh, this is not a reference.
reference case, not a reference
It
case.
is not a reference. It is his case. Lordship is aware that if a dispute is raised and if it is not referred within 45 days, then the aggrieved workman in the case of termination, retrenchment, and removal from service can directly approach. So, this is his case. He has come under 2A directly to the Labour Court. So, his case before the Labour Court was he was wrongly retired from service.
Where is that? Ajab, let us have it on another date. I'll keep it. I've heard in part, so maybe next week. Only thing is that I'm not sure which day I'll be sitting single. So I'll say as and when the single bench is available. Next week. Is that because there is one another part heard.
If your lordship is sitting single next week, your lordship is not.
So I'm not aware on which date single bench is going to be available.
In that case, my lord.
Otherwise, my case is simple. Not in my case, they ought to have proved under Assam plantation
No,
level, producing that race.
Arguments are more or less completed.
Argument
Let
is
me have a
nothing.
look at it. Should I say arguments are completed then?
Lordship.
Or you want to say something more?
If my friend want to say something.
I would like to add one thing, my lord, in respect of his argument that it was our duty to bring all these registers and all. For a moment, if
you will have to take me to the Evidence Act to show who it was on whose onus to prove. You see, we might have to
114
go to that.
explanation G, Lord.
my lord, the question is, we have a certain thing in the record showing his date of birth, and we have produced it. Now it is
Mr. Chakravarti, PF nomination cannot be a record. PF nomination is a form which he has given, but as I have said, in every establishment there has to be a register, and the Assam Plantation Labours Act clarifies you must have a register where his name is entered. There is a form. Now, what is the date of birth recorded in that form? That is all that you needed to show.
Now,
that is all that you needed to show to establish that this is the date of birth. And
in that
especially in a
case,
case
if
where
the
the PM nomination form is being disputed,
my lord,
specifically in a case where that PF nomination form is being disputed,
now
your
here it
register
is-
would have clarified. If suppose your register has that date which is there in the PF nomination, end of it.
even assuming
Correct.
yes, is one way of looking
Yes,
at it.
yes.
Other way, we have not brought it. What is the explanation why they have not applied for and to draw adverse inference, then that attempt ought to have been made.
That
Number two,
I've understood.
my lord, if assuming everything that
Right,
if,
you file your written arguments.
if that
Both of you.
1154
Very
is
well.
wrong,
Arguments
the-
are completed. Let written arguments be submitted on the next date of listing. List after 1 week on a day. List after 1 week as and when the bench is available. Obliged.
My lord, I met to item 26. I was on next in other court.
26, I think I have already passed the order. You have to also admit that before if the authority, your authorities are at liberty. They may accept the disciplinary inquiry report. They may not. They may disagree with the inquiry report. There is no difficulty. But if they disagree, the grounds of disagreement must be given to the delinquent. How can they act contrary without letting the delinquent know? Now, in this case, it is apparent because we cannot improve the records.
it is
Correct.
apparent. So
It is
therefore-
apparent from that second show cause notice that the second inquiry, the only inquiry report, because preliminary inquiry is a fact finding. That is different.
Preliminary
Correct.
inquiry report, it has not been taken into account by the disciplinary authority.
No, that order you read, it does.
No,
Because-
therefore, my lord.
Of course, it does. Kindly see page 88.
Yes, page 88.
Page 88.
No,
The
page
Deputy Commissioner, Karbi Anglong District, on receipt of the complaints against you,
No,
appointed.
no. It's a part. Therefore, my lord, I will have to read it.
No. You read it from here first.
No, page 88.
Page 88.
Yes.
Deputy Commissioner, Karbi Anglong District, on receipt of the complaints against you, appointed Sri so-and-so ACS and so-and-so Karbi Anglong and so-and-so ACS and Executive Magistrate so-and-so to conduct an inquiry in the allegations as reported and submit report. Correct?
That is the preliminary inquiry.
As per the report
Yes.
of inquiry officers, you were found not following the proper procedure
Yes.
for smooth clearance of the March ending bills,
Yes.
checks, and you had done partiality in disbursing bills by breaking the precedence of issue of token against the bills. An FIR had also lodged at Diffu Sadar police station against you. Now, this is the report of the three officers, correct? Now, when you turn and you go to
page 90,
yes, kindly see here. Whereas to conduct inquiry
yes,
on the charges made against so and so,
yes,
Sri so and so was appointed as inquiry officer.
and Srimati
So
Malavika
and so
Chaudhary
was appointed as so and so. The inquiry submitted his report on 2/2/2022.
Yes.
Whereas the report submitted by the inquiry officer in respect of the departmental proceeding
Yes.
was forwarded to the charged officer on so and so.
Yes.
Whereas so and so submitted written submission. Whereas the above reply of the charge officer was examined and it is found that the charge officer has neither raised any objection about the inquiry process nor placed any so and so.
Yes.
Whereas the appointing authority so and so directed to impose major penalty.
Yes.
Now, if you come to the show cause notice,
yes,
which is at page 87. No,
Yes.
sorry, show cause is
63, my lord.
63.
63.
60 second show cause notice. That is-
63.
That is with regard to the final inquiry report.
Correct.
Yes.
This inquiry report is this inquiry, isn't it?
Yes.
The inquiry report of this person.
21, my lord.
Huh?
Page 64 onwards, it is enclosed.
Correct. So that is the report of
The departmental.
departmental inquiry of Sri Ghanakanta Pegu ACS, and
Yes.
that is the report, isn't it?
That is the report.
Now, in that report, there is nothing adverse.
Yes. No, therefore, my lord.
Are you following what I am saying? Because let's not
No,
unnecessarily.
Absolutely correct.
Let
But-
us understand what are the facts, first of all, admitted. So,
Yes.
in that inquiry, which you have referred, there is no, you can show me if I am wrong, correct me, that the inquiry, departmental inquiry have noticed that the delinquent has not followed the procedure or had done partiality. Is there any observation?
My lord, that is why, my lord. That is why, because apparently, if we read the papers, my lord, it appears, my lord, that Rule 9A
has been flouted. This is the argument.
I am not going into all that. You show me from that inquiry report.
Yes, definitely.
Where is there
Now-
finding in that inquiry report that he has not followed the procedures?
Absolutely, Lordship is correct. Now, the nature of penalty that has been imposed.
Those will go later.
Yes, no, my lord, why I am making
No,
that
Mr.
submission?
Borpujari, you see, those are not right now. First and foremost, you need to show this court that that inquiry report of the departmental proceeding, which by relying, you have passed the
Yes,
penalty.
Yes.
There are findings.
There is no, my lord, my submission would be, there is no occasion for recording any disagreement for the plain and simple reason that, my lord, the inquiry officer has not in categorical terms, my lord, has not in categorical terms, my lord, absolved the delinquent officer from the charges. This is my argument, and this is substantiated from the pleadings laid down before this honorable court in my affidavit.
Where is that inquiry report?
Yes.
Page 64.
Now, yes, Lordship, for a moment, Lordship may be pleased to take up page 63. This is the forwarding letter.
Yes.
So the petitioner, that is the delinquent officer, has been put to notice that an inquiry was conducted where you participated, and this is the finding. What you have to say about the findings. So the principles of natural justice has been fulfilled to that extent, my lord. So far as page 63 is concerned, what page 63 says, my lord, with reference to the subject cited above, I am directed to forward herewith a copy of the inquiry report as submitted by the inquiry officer in the departmental proceeding drawn against you for your ready reference. You are therefore directed to submit written reply within 7 days from the date of receipt of the letter. Now he is put to notice. From page 64 onwards, Lordship will find the inquiry report. It is from Ghonokanto Pegu, he is the inquiry officer, and this has been furnished to the highest authority, that is the principal secretary. Now, what does it say, my lord? I have the honor to state that I have been appointed inquiry so-and-so. Accordingly, inquiry into the charges in the departmental proceeding has been conducted. To begin with, the articles of charges drawn up so-and-so by the commissioner and secretary have been reproduced. These are all reproduction of the charges. Page 65, Lordship will kindly see. That is charge number 1. Charge number 1. At charge number 1, my lord, down below in the third paragraph, within charge number 1, my lord, I am reading it. It is therefore evident, Lordship got it, my lord. I am so obliged. It is therefore evident that you were indulging in gross indiscipline in your office by deliberately neglecting the laid down principles and procedures required to be followed in a treasury office while dealing with the bills, and thereby setting an example before your juniors how to flout government practices. This of your behavior amounts to misconduct and is quite unbecoming of a government servant. This is charge number 1. Charge number 2, Lordship will see there. It starts from page 65. And then, my lord, page 66. Page 66, the second paragraph. It's a continuation of charge number 2. Of course, there were 2 charges, my lord. There was no sanction order for issue for drawal of the amount seized. Moreover, as per Finance Department instruction, the government money shall not be transacted in cash. Had it been an amount payable to a person on bill, it would have been deposited in his personal account. On the other hand, bank do not authorize to draw such a huge amount in a single day. Thus, the money has come evidently from unknown sources, which could be nothing but amount to realization of bribes. Because a huge sum of money, prior to that, again, I am troubling, my lord. Lordship may kindly come to page 65. My lord, the last paragraph.
Yes. Again on.
Again, before that also, I am reading charge number 2,
Yes.
because charge number 2 assumes significance here.
Yes.
That while you were working as treasury officer, this is a finding of fact.
Yes, yes.
While you were working as treasury officer of Depot Treasury, as per report of the inquiry officers, cashes amounting to rupees 4,000 was recovered from your office and seized on so-and-so by the inquiry officers ADC, accompanied by magistrate and police personnel led by DSP Depot. When the team visited to seal the office of the treasury officer Depot, as per the report, the money was recovered while opening one of the unlocked drawers. Keeping cash in your official drawer is sufficient to raise question about your integrity, as it is unbecoming of a
So
government
both the
servant.
charges otherwise seems to have been proved before the.
Yes, yes. My lord, the last paragraph. Kindly see the gravity of the charges. This
Yes.
is, my lord.
Keeping
And
cash.
I'm so obliged, my lordship is bearing with me, my lord. Again, on 3/4/2019, when the Depot Treasury Office was opened amidst presence of magistrate, police officers and staff, a search was conducted and subsequently an amount, this is a substantial amount, 5,76,100 was found and seized. Since the money was recovered from the locked locker of your office chamber along with your identity card. Such huge cash in your office drawer establishes the allegation that you were habituated in taking bribes using your official position for clearing the bills for payments. Now, these are the charges. Then, page 66 down below, lordship will kindly see list of documents. Everything has been taken care of by the inquiry officer.
Oh, the first document is also given.
Yes.
The fact finding.
Yes.
Inquiry report.
Yes, he is put to notice with everything. Therefore, whether 9A is flouted or not, if at all. Then, my lord, page 67, kindly see, my lord, list of witness. Then, my lord, next, the reports submitted by the DC Karbi Anglong, so-and-so, ACS magistrate, so-and-so, have been perused, which are as follows. With reference to the, I am submitting here inquiry report. Various inquiries were conducted, even by the, my lord, the jurisdictional police authorities also. Statement were recorded. Kindly see, my lord, page 68. Then statement of Amarendra Sharma, that is the delinquent officer. Then, my lord, this is page 69, lordship will kindly see. Page 69, the next page. Now, this is a report, my lord, from the
last paragraph.
Yes,
There were serious allegations.
Serious allegations of rampant corruption and irregularities committed by the treasury officers. These are all findings. Then, page 70, kindly see, my lord, page 70. Page 70.
Now, this is the finding. Whose finding is this?
These are the findings of, my lord, the earlier inquiries, which have been preliminary inquiries, which have been, my lord, relied upon by the inquiry officer while conducting inquiry. Relied upon. Otherwise, this could not have been a part of his inquiry report. It is plain and simple.
Yes.
Then, my lord, page 71, kindly see. Page 71, the last paragraph. Page 71, last paragraph.
The above facts prove.
Yes, my lord, the above facts prove that the treasury officer was fully responsible for non-clearance of checks amounting to rupees 80 crores.
Substantial
70
amount.
lakhs. Kindly see. And, my lord, who is the signatory? Kindly see down below, my lord. Director of Accounts and Treasuries. He is the highest authority. He is the, my lord, officer who is responsible for all the treasury establishment in the state of Assam. Then, my lord, 72. Also examine the report submitted by Indian Borua, APS, Additional Superintendent of Police. The authorities have swung into action and have committed a thorough inquiry. Now,
And these are all taken note by the disciplinary.
Now, my lord, everything
the departmental inquiry.
Departmental inquiry, my lord, it's a bulky report. It is a bulky inquiry report.
Right. Let's come towards the end now.
Yes, towards the end. Then, my lord, lordship will kindly see the. Then.
Ultimately, what has been
ultimately,
done?
yes, I'm coming, my lord. I'm coming. Then, my lord, will kindly see, my lord, page 83, because page 84 is the last page of the inquiry report. Before that, page 83. So, what the inquiry officer does?
82, I think. While these are the after thorough examination, let's read from there.
Yes.
82 last.
Yes, 82 last. After thorough examination and minute scrutiny of the reports and statement of all concerned inquiry officers as enumerated above, the following two observations can be deduced in a broad-based manner. Number one, while serving as treasury officer, Amarendra Sharma adopted various unfair means while passing the bills submitted to the treasury office. He preferred to consider bills without following due procedure and cleared the bills in consideration of bribes. So people were aggrieved by his action. This is the finding of the inquiry officer himself.
Observation, not finding.
Whatever it
Please
is.
read, Mr. Officer.
Secondly, a cash amount was recovered from his so-and-so. Again on so-and-so, the Depot Treasury Office was opened amidst pressure of magistrate and the staff, and an amount of rupees 5,76,100, which your lordship has just seen a reference in a preceding page. My lord, all these have been, my lord, taken care of. Then, to the above charges, replies of Amarendra Sharma have again been thoroughly examined and minutely scrutinized. Now, what he says, my lord, the statements of, my lord, the delinquent officer, that is the petitioner out here, lordship will find the summary is appearing at page 83. Summary is appearing at page 83.
I have not understood after doing all this.
Yes.
Why at page 84 it says he should be
Yes.
acquitted?
Yes. So our contention is that, my lord,
That part is skipping, my lord.
Huh?
That was reflected by his keeping. I can point it out just now, my lord.
What?
The query from your lordship, the answer to that query is skipping.
No, but Mr. Bhattacharya is fairly taken me through the
No,
entire report. It
no.
appears that various levels, including the departmental inquiry,
Yes.
has recorded that
Yes.
the officer has floated the
No,
procedures
departmental
and money has been seized and recovered from the office chamber.
That is where my lord, I humbly state that the relevant portion he has not placed.
All right, you pointed out that in your
Yes,
turn.
yes, madam.
Yes.
Now, having said and done in so many words recorded, page 84, Lordship will kindly see, an objective, non-partisan, impartial, and disinterested observation on the charge number 1, level against, leads to the conclusion that he may be reasonably acquitted from the charge. What the inquiry officer says, inquiry officers normally what the inquiry officer says, that he is found guilty or he is not found guilty.
He's already given
Yes,
his.
it is not. So the wording is not happily worded. That is my predicament, my lord. That is my predicament. Therefore, my lord, there is no occasion in my respectful submission, my lord. There is no occasion for following the procedure laid down in Rule 9A.
What is that?
Yes, that is disagreement. That is the disagreement.
Rule
9A of the disciplinary appeal rules. That is what has been harped upon by the petitioner out here. Now, before that, Lordship, may I kindly see, my lord?
Yes, yes.
My lord, Rule 7, the nature of penalties. I'm troubling, my lord, with the rules, my lord. Nature of penalties, Rule 7. Rule 7 says the nature of penalties, and it is the major penalty.
But, Mr. Bhattacharya, I don't know. I'm finding it very difficult
That
to
is what?
understand page 84.
84.
Because you have shown me that both in account of both the charges, the present inquiry officers have found the petitioner guilty.
Yes.
Those two charges
Yes.
where
only
you have read.
Yes, only the last
Correct.
penultimate portion is not happily worded.
But
So
here he
therefore-
says maybe acquitted.
No, maybe acquitted. So maybe acquitted is not, my lord, a finding
And
that he is not guilty.
the inquiry officer.
Kindly see, my lord, charge number 1. And what is with regard to charge number 2? Lordship has seen charge number 2. Grievous, my lord, corruption.
There
Kindly
also
see.
initially it was said.
No,
that-
initially, kindly see,
Correct.
my lord.
Now it's saying it is felt that not much deliberation is
not much
required.
deliberation is required.
What kind of finding is this?
Yes. So therefore, my respectful submission and what has been done by the disciplinary authority is that, my lord, disciplinary authority has construed this
And what is
inquiry
this
report.
third paragraph?
Yes. Prosecution sanction order has already been granted against in the matter of recovery of money from his logs. That is, my lord, the criminal proceeding. So, and law which take its own course. The matter is sub judice and is beyond the purview of my jurisdiction. Lastly, since the proceeding of prosecution sanction order may take longer time to dispose, in the meantime, the authority of finance department may suitably consider for his reinstatement in as much as his service should be utilized instead of allowing him to enjoy the
Now
benefit.
come to the rules.
Yes. Now, rules, my lord, kindly see. It is not a case that the inquiry officer has not recorded the observations or finding for that matter, my lord, that there is no, my lord, he has not committed misconduct. It is not the case, my lord, coming out from the inquiry report that there is no misconduct. It is not in clear words from the inquiry officer. Inquiry officer says in a other way around. He says, my lord,
You see, that is the difficulty,
that is
Mr.
the-
Bhattacharya.
Yes.
Since it is not clear, what opportunity are you giving to the other side? Please bear with the court also.
Yeah, absolutely.
Correct.
Absolutely.
Because this court, no matter how serious the allegations and whatever the materials have come forward,
yes,
can bypass the
mandate of
principles
law.
of natural
Yes.
justice, right?
And that too, my lord, the mandate
Correct.
of the rules.
Now, before I go to the rules or I see more papers or I hear Mr. Patwari,
yes,
it is evident from the inquiry itself that sufficient materials appears to have been collected against the delinquent. Be that as it may, in the last paragraph, the inquiry officer makes it very clear that it's a case of acquittal.
Yes.
Charge 1. Charge 2, no deliberation required.
Yes. No.
Now, what do? You put this inquiry and say you give comments. What comments will the delinquent give? Because this inquiry officer at the end is saying that he may be acquitted.
But he may be
Now,
acquitted.
if it was a situation where you are going to disagree, then you should have given him an opportunity where you would have clearly said that though these are our findings, however, it appears so and so, but we are unable to agree. Now, what do you have to say?
Yes, absolutely.
What prevented you from doing that?
Yes, but my submission.
Let's see the rules.
Yes.
Because there is one way is to put it back to this stage.
Yes.
To this stage only.
Yes.
Where you can give him that notice.
Yes.
And proceed.
Yes.
That is one option.
One option.
If this court comes to a finding
Yes.
that violation of natural justice.
Yes.
Anyway, let's see the rule.
Before that, my lord, the so-called reply. If lordship may be pleased, he has given only a 2-page reply. 2-page reply to the inquiry report.
Yes.
Pages don't matter.
Yeah. Why these kind of practices has been adopted in our courts nowadays, where all these commentaries are being made when one person is arguing? I simply do not endorse such behavior in the court.
I apologize.
I'm sorry, but not accepted.
I apologize.
Mr. Patwari?
I apologize.
Yes, Mr. Barpujari.
He is much better than me in service jurisprudence. Maybe my lord, he is excited.
He may be better, but excitement you have to
Excitement, yes.
keep it under control.
I'm so deeply obliged, madam.
Yes.
Yeah. Now, reply to the inquiry report.
Yes.
At page 85,
Yes.
the second paragraph, that the 2 charges have been brought against me by so-called notice being so and so, that the inquiry, last paragraph, my lord, inquiry officer conducted during inquiry, statements have been recorded, taken into consideration from, apart from giving me an opportunity to place my case. Kindly mark, my lord. Apart from, my lord, page 85, the last paragraph, that the inquiry officer conducted the inquiry as per law and by following due procedure.
During such
inquiry, relevant witnesses were examined and their statements recorded. Documents, reports
That
pertaining
is during the inquiry stage.
He is satisfied with the inquiry report.
All right.
Yes.
Because you see the inquiry report acquits him.
Acquits him. That is the penalty made. My decision of
but that is why I'm trying to tell you.
Yes.
Now you see that is not clear. He is understanding it in that manner.
My lord, yes. Now, my lord, the last line at page 85.
Yes.
I am in a very precarious catch-22 situation. I have to trouble your lordship.
True. No worries. You can keep troubling me. I'm here for you all. Yes.
I am so grateful. Documents, report pertaining to the matter were also taken into consideration, apart from giving me an opportunity to place my case. So he had placed his case clearly. Now, the inquiry, page 86, my lord, the last but the above paragraph, that the inquiry officer has been further pleased to recommend that instead of allowing me to avail subsistence allowance, I may be reinstated so that my services may be availed by the authorities. And under the circumstances, I respectfully pray that your good office may be pleased to accept the report of so and thereby exonerate me for all the charges. Yes, he's now making that.
That is how he's understood.
Yes. Now, my
Mr.
lord.
Abdullah, any criminal matters today? Yes.
Now, my lord, let us come to the impugned order.
Yes.
Before delving into
87.
Yes, page 87. I'm so grateful, my lord. Now the search number 2, everything has been said. Now lordship was referring to page number 90.
Page number?
90. My lord, the third paragraph.
Yes.
Whereas to conduct inquiry on the charges made against Amarendra Sharma, so-and-so, so-and-so was appointed as inquiry officer, so-and-so was appointed as the presenting officer. Inquiry officer has submitted his report, whereas the report submitted by the inquiry officer in respect of the departmental proceedings was forwarded to the charged officer, that is admitted position, whereas Amarendra Sharma submitted his written submission regarding the finding of the inquiry officer, so-and-so, whereas the above reply of the charge officer was examined by the department, and it is found that the charge officer has neither raised any objection about the inquiry process, nor placed any material on record to prove his innocence. Whereas the appointing authority, that is the finance department, after consideration of all the facts mentioned above, decided to impose a major penalty of dismissal from service, which shall ordinarily be a disqualification for future employment. That is to be found in Rule 7. I will be inviting Lordship's attention to Rule 7. Then page 91, the last page, my Lord. Whereas as per procedure laid down in Assam Services Discipline Rule and so and so, the Public Service Commission was consulted. This is what, my Lord, the rules say. Everything was done. Whereas the Assam Public Service Commission agreed to the penalty proposed to be imposed upon so and so. This is also the admitted position. My learned colleague is not disputing this. In view of the above, now these two, my Lord, last two paragraphs. In view of above, I so and so, IAS, Secretary to the Government of Assam, removes C so and so from the Assam Financial Service with immediate effect, which, and this shall be ordinarily be a disqualification for future employment, then suspend. Now, my Lord, the affidavit which we have filed says the tenor of the affidavit is there.
Before we go to the affidavit, let's come to the rules.
Yes.
Relevant rules.
Relevant rules. At the first instance, Lordship may be pleased to peruse Rule 7
of
Rule 7 of the Discipline and Appeal Rules, 1964. Rule 7 speaks about the nature of penalties.
Yes.
Rule 7, my Lord,
Yes.
Sub-rule Roman 7. My Lord, Sub-rule Roman 6. I'm so sorry. Sub-rule Roman 6.
Removal from service.
Yes, this is the penalty which has been imposed in the case in hand.
All right.
Removal from service which shall not be a disqualification for future employment.
All right.
Yes. Now we go down below and, my Lord, procedure for imposing penalties.
Yes.
That Lordship will find at Rule 9.
Yes.
Rule 9, down at Rule 9, Lordship will kindly come down to, my Lord, Sub-rule 7. Rule 9, Sub-rule 7.
Yes.
At the conclusion of the inquiring authority shall prepare a report of the inquiry, recording its finding on each of the charges together with reasons therefor.
Yes.
This has been complied.
Yes.
There is no disagreement.
Yes.
Now, my Lord, then the explanations, my Lord.
Yes.
Then major penalties. Lordship will kindly come to, my Lord. Sub-rule 10. Major penalties.
So this proviso is important. Explanation.
Explanation, yes. If in the opinion of the inquiring authority, the proceedings of the inquiry establish any charge different from the original charge, it may record it. This is not applicable here, my Lord.
Next.
Yes, provided that the findings on such article of charge shall not be recorded unless the government servant has either admitted the facts on which a charge is based
So
or
this is
has
not relevant.
he has reasonable opportunity of defending himself.
This is required.
Yes, reasonable opportunity, which is the admitted position. He says against the inquiry report in the two-page so-called reply, when the final inquiry report was furnished to him, he has, my Lord, supplied, my Lord, made a representation. That is the so-called reply, two-page so-called reply, which Lordship has just now seen. There he is happy with the inquiry findings.
Obviously, he'll be happy.
Yes.
Obviously, he'll be happy.
So
because of that conclusion para.
No, conclusion para we are coming, my Lord. Now,
No.
before that.
That conclusion para is very clear.
Yes.
Acquit.
No,
Charge 1.
No, that is
Charge 2, no further deliberation.
That is the expression of.
And recommendation is reinstatement.
Absolutely, my Lord. My respectful submission is that is
Mr. Borpajari, you see, that is how he's understood and he's replied.
My Lord, what I understand,
Anyway,
my Lord,
I'm appreciating your argument.
My Lord, what is happening? My Lord, the inquiry officer.
In other words, what you're trying to submit before this court, Mr. Borpujari, is that the gist of the charges and the materials that have been collected and all the previous reports have been elaborately dealt by the inquiry officer in that report, from where it is evident, manifestly evident,
absolutely,
that the petitioner has violated the procedures and has accepted bribe.
Yes,
correct.
I'm so grateful, my Lord. Now,
no problem.
Yes, now,
but
yes,
despite all this,
yes,
what does the inquiry officer say?
Yes,
he says Charge number 1, acquittal. Charge number 2, no further deliberation. Reinstate.
Yes.
And what does the authorities does? Disciplinary authority? They say this is the inquiry report. You have to say something. You say he has seen.
Yes,
He finds that despite all these evidence and materials, inquiry officer is satisfied
Absolutely.
that there is no case.
No case. Now, my
What
lord,
more will he say?
yes, my lord, my
Are you understanding?
Yes, my lord, in my submission, I am trying to dissect the inquiry report into two parts. The first part.
Are you allowed in law to do that?
Yes, my lord, definitely, because
No, because you see what is required here
my lord,
is opportunity, full opportunity.
Absolutely.
Now, if it is not clear, how can it be said that the petitioner has got full opportunity?
Now
We
my
are
lord-
only on this. We are
Absolutely.
not on anything else.
Absolutely.
Because if right now I go to anything else, it would prejudice either of your cases.
Absolutely.
So I am not on
so glad-
merit.
Yes, my lord.
In
but-
fact,
yes.
to be fair, it appears
Yes.
that this inquiry report is it doesn't inspire the confidence of this court.
Yes.
Mr. Patwari, it does not inspire. But be that whatever, opportunity has to be given.
Opportunity.
If you
Now-
want to take a different view,
Yes.
where
Now-
is that opportunity?
Yes. Now,
And you made me read that 2-page reply. That is further clear how they have understood.
Yes.
And in that manner, they have replied.
Absolutely. Now, my
And
lord,
I don't find anything wrong in their perception because that is a perception which your inquiry officer has given them.
given them. Now, my lord, my respectful submission is, my lord, the findings and, my lord, the expression of mind. Now, the inquiry officer has taken into consideration all the preliminary inquiries, all the materials, all the evidences that go against him. Despite having done so, he expresses his mind in the last part. Now, therefore, my lord, my argument, I am trying to dissect the inquiry report into two parts. What
Mr.
that is the reason.
Bharpujari,
My lord,
I am sorry I am cutting you short.
My lord.
But suppose the court
my lord.
gives a judgment,
Yes.
and in that judgment, the preceding paragraphs are paragraphs where the court discusses all the materials and finds these and finds that the petitioner has done something which is not as per the law.
That is the dictum.
However,
Yes.
while giving the main order, says that we are satisfied that no case is made out.
Yes. Therefore, Lordship has
Then-
so fairly, my lord, indicated me that I cannot improve the record.
Then what exactly?
Yes.
That is what Mr.
Yes.
Bharpujari.
Yes.
At the end of the day, you are an officer of the
Yes,
court
yes,
only.
yes, absolutely.
You cannot go
Yes,
beyond
yes.
the record.
Yes,
Now
even
we are
if-
faced in that situation.
Yes.
Mr. Patwari, you were mentioning one case yesterday.
Yes, I would like
Which
to-
is that case?
No, not only one case, my lord.
So, one case is sufficient if
No, my
it
lord,
is on the point,
I-
because you mentioned that in case of disagreement, some
Directly on that point, I'll place
yes,
one
which is that decision. You give us let Mr. Bharpujari also be benefited with that decision.
Yes,
If he wants to distinguish, he'll distinguish.
My lord, only two areas of my submissions are left.
All
My
right,
lord, let
all
me
right,
submit
all
that,
right.
my lord. Now, my lord, Rule 9A, Lordship may kindly see.
Rule 9?
9A. This is what has been harped upon heavily by the petitioner.
9A.
9A.
9 capital A.
9 capital A. Communication of order. This is the case of the petitioner.
9A.
9A.
Capital A. my lord.
Nine capital A.
In the
my lord.
Assam service,
Lordship,
It has been
9A
inserted by an
to
amendment
98.
in
yes,
the
sir, it's there. I can point it out.
amendment. After amendment, it is there. My lord, in the year 1977, it was amended, and 9A was brought in.
Communication of order.
Yes,
Communication of order.
yes,
May I read it, my lord?
yes, please.
I'm so obliged. Communication of orders. Orders made by the disciplinary authority shall be communicated to the government servant, who shall also be supplied with a copy of the report of the inquiry, if any, held by the disciplinary authority, and a copy of its finding on each charge. Now, or where the disciplinary authority is not the inquiring authority. Now the present case comes within this provision, my lord. Where the disciplinary authority is not the inquiring authority, a copy of the report of the inquiring authority and a statement of the findings of the disciplinary, yes, with a brief reason of his disagreement.
Very clear.
Yes. That is why, my lord, I must be fair to the court.
You are always fair to the court. There is no doubt about it. Both of you. But we this court, and we all have to go by the records. That
even my lord.
that is why I'm saying, Mr.
My lord,
Barpujari,
I have secured all the original records for the shadow copy. Even I cannot improve I have kept it
you
aside.
cannot improve it.
Yes.
It is beyond because this should have been done. So
Yes.
I can send it back to that stage.
Yes. Then
Where?
my lord, one last submission.
Yes, yes.
Of course, lordship will not.
Yes, yes.
My lord, there are provisions for filing department and appeal. He could have filed.
Violation of natural justice. All Whirlpool. 1999.
I just stopped here. I just stopped here.
You have appealed my heart, but my mind is not with you.
My lord.
Sorry.
I'm always grateful, my lord. I'm so
Right,
grateful.
it's almost 1. So at 2 o'clock, there is one judgment which is almost ready. I will just pronounce it, and thereafter I'll dictate.
My lord,
Lordship, actually, before dictating, just 10 minutes time, I will.
You want something more?
Yes,
What?
I will have to clear.
All right, I'm giving you.
Yes,
Take it.
Yes, I can take it.
Yes.
Lordship, kindly bear with me, my lord.
Yes, I'll bear with you. There is no difficulty.
Lordship, the petitioner was serving as a treasury officer before. It was
Mr. Patwari, I will not be
Lordship,
giving you any further relief. All I am going to do, I have made it clear.
I bow
You
down to
have.
your
I am inclined to allow the
Lordship,
repetition only to that extent.
No, Lordship, I have to answer. There is a question or query going into this honorable court's mind. Why, after observing so much, why this?
I am not entering into that area,
No, my lord,
Mr.
it is
Patwari.
on record. That I have
But be that as it may, you see, I'm not going into that. I will only adjudicate the issue of principal justice right now.
absolutely. And I have to
I'm
assess
not
it.
going because it appears that there are sufficient
I will
materials.
not go into the
So
merit.
I will not go into
I
all
will
that.
not, I myself will
Yes.
not go into the merit. I will try to assist the lordship on the law points which needs to be cleared,
Yes,
my lord,
yes,
because
yes.
some
All right.
confusion has arisen.
Yes.
My lord, on that date, it was a March ending 31st of March 2019, when the incident happened. 194 crores were withdrawn by the case.
You are on merit.
No, this I have to make this statement. Apart from this, I will not make any statement. 194 crores were withdrawn by the Karbi Anglong Autonomous Council. So, my lord, only 24,000 cash was left with the Treasury Office. So, all bills could not be cleared.
You say all that in your reply.
No, it's there. It's
Yes, and further, when you get that fresh notice in that situation, you reply.
That's what
This court and 226 is not going to go into all this, Mr. Patwari.
Kindly bear it. Kindly bear it.
Yes.
My lord, and thereafter, my lord, everything is before your lordship what has happened.
Yes.
Now, when the preliminary inquiry was conducted, that those not one, there are many inquiries which are placed before the departmental inquiry officer. Departmental inquiry officer took note of each and every preliminary inquiry, including the charges. Now, lordship will kindly turn to page 83.
You see, Mr. Patwari, I will go to 83, but I am not understanding why are you taking me to all this? Because I am with you as far as
Yes, yes, I'm understood.
but you see, more than that, this court is not going to go into 26.
Lordship will kindly.
The authorities have a right to disagree with the
Yes,
inquiry report
absolutely,
and do whatever is to be done.
Absolutely. I
There,
have to
in
only-
fact, the Rule
I have quoted
9A,
that. That is my prayer.
correct?
Yes, I have
Rule
quoted
9A provides. Now,
Quoted
in that situation, why should this court go into all this?
that. No, lordship will not. Just, my lord.
Page 83.
83. After observing all the preliminary inquiry reports, page 83, penultimate para.
If you are, I may put you at caveat that you are inviting risk.
No, my brother.
I'm telling you,
Yes, sir, I can
because I am not satisfied the manner in which this page 80, 83, 84 has been given. Absolutely, I'm not.
I have got your
This is quite a lengthy report.
Because all the reports
Prior
are-
to page 84, everywhere Materials are against you.
No,
And suddenly, at page 84, acquittal?
all the.
I'm telling you, you're inviting risk.
No, that's why, my lord. That's why I have to place the law, my lord.
Yes.
The inquiry report is bulky because all the preliminary inquiry reports are quoted there. Lordship will kindly penultimate para of page 83.
Yes.
In this regard, it may be mentioned that the available record of PLM means personal ledger account for the month of 2019 clearly shows that on 31st of March 2019 at 9:40 p.m., hardly rupees 24,724 only is left. Hence, no further bill of Karbi Anglong Autonomous Council could be passed by the TO, that is Treasury Officer, copy of the so-and-so annex. Now, this is very important. The core point of uproar and anger of the people is that their bills were not passed. The bills were not passed because of paucity of fund in the Council of PLA. The inquiry officers did not touch the point at all, other than irrelevant aspects have been emphasized.
This is what you have said.
No, this is the finding of the inquiry officer, departmental inquiry officer.
No, on top it says to the above, Sri Sharma replies.
Yes, the first paragraph is my reply, first and second.
Second paragraph.
But third paragraph, last paragraph and penultimate paragraph is not my reply. This is the finding of the inquiry officer. This has to be read harmoniously with the page 84, my lord.
All right.
Yes. Now, Lordship, I will place the judgments, my lord. Facts, it's already there. My lord, there are now two aspects. The Rule 9A, there is a statutory violation. There are direct judgments, and two judgments are placed. But what are the consequences of a preliminary inquiry if there is adverse finding? Supreme Court has said the moment a departmental inquiry is, my lord, started, it loses its importance. I'll place the judgment. Lordship, it's 2013 Code STC, page 301.
You give me, you have the citations?
Yes.
All right. First, you give me the citation, 2000?
2013 Code
Yes.
STC,
Yes.
page 301,
301. Paragraph?
Paragraph 52.2.
52.2. Just mark that paragraph.
marked.
Huh? And this is on the point that preliminary inquiry loses its significance
The
once
report,
the
yes,
departmental
yes.
inquiry submits its
Yes,
report.
yes.
All right.
Yes, may I read the paragraph, small paragraph? The inquiry officer, the High Court on the administrative side as well as on the judicial side committed a grave error in placing reliance on the statement of the complainant as well as of Sri C.B. Gajjar advocate recorded in a preliminary inquiry. The preliminary inquiry and its report loses significance stroke importance once the regular inquiry is initiated by issuing charge sheet to the delinquent. Categorical finding, my lord.
Okay.
And my lord, I will place one constitution bench judgment of 5 judges, where the Honorable Supreme Court has said preliminary inquiry and departmental inquiry are two different stages, and both the, my lord, proceedings should not be confused, my lord. Lordship will find AIR 1964.
Yes.
AIR 1964 SC 1854.
1854. Para?
Para 12 and 13. I need not.
That's all right. Next.
Yes. For the proposition that the court should not confuse between preliminary inquiry and departmental inquiry. Preliminary inquiry is only for
Understood.
arriving at satisfaction whether.
Understood, Mr. Patwari. Next.
Now, my lord, the two judgments on the issue, my lord.
Disagreement.
Yes. The first on judgment in this regard, it was reported on 1995 6 SCC 157.
One second, go slow.
Sorry, my lord.
Yeah.
I'll refer to 1995
1995
6 SCC page 157,
157.
para 10. I'm giving
Para?
10, 10. I'm giving a copy, a small para, I will read my lord. Small para.
Yes.
Para 10. The next question is whether so-called notice is valid in law. It is true, as rightly contended by the counsel for the appellant, that the so-called notice does not indicate the reason on the basis of which the disciplinary authority proposed to disagree with the conclusions reached by the inquiry officer. The purpose of the so-called notice in case of disagreement with finding of inquiry officer is to enable the delinquent to show that the disciplinary authority is persuaded not to disagree with the conclusions reached by the inquiry officer for the reasons given in the inquiry report, or he may offer additional reasons in support of the finding by the inquiry officer. In that situation, unless the disciplinary authority gives specific reasons in the so-called notice on the basis of which the findings of the inquiry officer in that behalf is based, it would be difficult for the delinquent to satisfactorily give reasons to persuade the disciplinary authority to agree with the conclusion reached by the inquiry officer. In the absence of any ground or reasons in the so-called notice, it amounts to an empty formality which would cause grave prejudice to the delinquent officer and would result to injustice to him. The mere fact that a final order, some reasons has been given to disagree with the conclusion reached by the disciplinary authority cannot cure the defect. My lord, and the last judgment, my lord, that I do give. On the same point of disagreement, my lord, 1998, this is also very important. 1998.
Yes.
7 SCC.
Yes.
84.
Para?
Para 17 and 19.
Yes.
My lord, Lordship has taken para 17.
Yes.
Recitam C, Lordship has.
Yes, I have started from there. The principles of
The
natural
principles
justice.
of natural justice would demand that the authority which proposes to decide against the delinquent officer must give him a hearing. When the inquiry officer holds the charges to be proved, then the report has to be given to the delinquent officer, who can make a representation before the disciplinary authority takes further action, which may be prejudicial to the delinquent officer. When,
This is absolutely the case here.
yes, the second part, when, like in the present case, the inquiry report is in favor of the delinquent officer,
But the
but the disciplinary authority proposes to
differ.
differ with such conclusions, then the authority which is deciding against the delinquent officer must give him an opportunity of being heard, or otherwise he would be condemned unheard. The departmental proceeding, what is of ultimate importance is the finding of the disciplinary authority. And para 19 also details the same thing, my lord. There was a regulation in that case, and that was violated, my lord. And the earlier judgment is also referred to as para 20 of this case.
But your rule is also,
Yes,
rule is clear.
Rule is clear, 9A.
This cleansing money.
Yes. We need not. There are two ways. One is an easy shortcut where by quoting the rule, one can just simply turn it back to that stage.
Yes. Excellent.
Because this rule is very clear, communication of orders.
Yes.
Or where the disciplinary authority is not the inquiring authority, a copy of the report of the inquiring authority and a statement of the findings of the disciplinary authority together with brief reasons for its disagreement.
Reasons for disagreement.
Correct.
Barely saying I disagree
If
on
any,
two.
with the findings of the inquiry authority.
Barely saying I disagree on two. You have to give reasons also why he disagrees.
That is very clear.
Lordship is taking this book, my lord.
Yes.
Can you kindly turn to page 459?
I am in 438 now. Yes, 439.
459, my lord.
459.
Yes. This is a departmental of manual, the manual of departmental proceeding.
Yes, 459.
Next page, Lordship. Page 460.
Yes.
Roman 8.
1 second.
Roman 8.
Yes. Preliminary.
A preliminary inquiry held with the object of ascertaining whether there is a case for framing charge against
Very
the-
well. This point, there is no quarrel to the proposition that you are you are trying to place bring home. But It has to be applied in the context of your case.
Yes.
You see, Mr. Patwari, in that inquiry report, at the beginning, there has been assessment independently also. Towards the end, the statements have also been there. That apart, they have also discussed the reports.
Yes.
Now, just because they've discussed the reports doesn't mean one will held that entire inquiry is bad, because in the inquiry also they have relied.
Yes.
So it will depend.
And
But
and
say
then-
for instance, in a given case where the inquiry constituted does not independently assess the materials or call for evidence, merely quotes the preliminary inquiry,
It's
then
open.
of course
It's open, my lord.
it would be in the context.
Yes.
Anything more?
My lord, I humbly respectfully submit that, my lord, this is the fifth case wherein this honorable court will interfere with the impugned dismissal order and reinstate me in service, my lord.
All right. So probably at 2:15, because there is one that judgment, of course, is ready. So next,
Where at the
Baki to our
disposal?
recommend? Yes, Mr.
Oh, where-
Patwari,
Where at the disposal?
and the TJ Mohanta was for R6, correct?
APSC.
6, I suppose.
Six, my lord.
Response number 6.
As far as state is concerned, I think it is Mr. CKS Borua who's
Yes, sir.
the concern.
Yes, sir. He has produced the instructions as your lordship. I just asked him to provide. the
Correct.
instructions.
I'm just reading out the operating part.
Yes, sir.
In the present case, it appears that the 1986 rules clearly provides the power to the state respondents to include any post or cadre along with the feeder post prescribed under the said rules for promotion to the next cadre. It further appears that the state government, in exercise of such powers, has taken the post of translator to be included along with the feeder post for promotion to the post of junior information officer, as evident from the letters dated 16/8/1994 and 21/9/1994. It further appears that in terms of the past practice prevalent in the Department of Information and Public Relations, the post of translator at all relevant point of time was taken to be a feeder post for promotion to the post of junior information officer. Hence, it is manifest established that the post of translator is taken to be included in the feeder post for promotion to the post of junior information officer. That being so, this court is of the considered opinion that the impugned promotion of the respondent number 7, who was holding the post of translator, to the post of junior information officer, is valid, legal, and in consonance with the 1986 rules. The arguments of the learned counsel appearing for the petitioners to the effect that the impugned promotion is dehors the rules is accordingly unsustainable, and the decisions cited in that regard are also not applicable in the facts of the instant case. In light of the aforementioned facts and circumstances of the case, I do not find any constitutional infirmity in the impugned promotion order of the respondent number 7. As such, there is no merit in this writ petition, hence the writ petition fails. Resultantly, writ petition stands dismissed. You will get it slightly later in the day. I will just, 1 or 2 page might need a little editing. Mr. Fukan, this court fully appreciates the arguments that you have made, but don't be personal in a case.
I'm not personal.
Why are you looking so sad?
No, I'm not at all.
This court really appreciates the work, the hard work that you have put, but that is all as a lawyer one can do. Anyway, sorry.
Obliged.
Item 28.
Item number 28. No? Heard Mr. J. Patwari, learned counsel for the petitioner. Stop. Also heard Mr. R. Borpujari, learned counsel for the respondent number
1, 2, and 3, Madam.
1,
1, 2, and 3.
1, 2, and 3, and R.S. Ronghang, learned counsel for respondent number 4 and 5. Hmm? 5, I think, Mr. Borpujari, you can appear. DC Karbi Anglong.
DC Karbi Anglong, only government advocate will have to appear.
You are for the government. Correct. So who is there for government?
DC Karbi Anglong has filed his affidavit.
No, but no government advocate is there.
Some government advocate can appear.
If you can get hold of someone, I'll put his name. Anyway, 5. No, 5 is DC. GS. Mati Pathabo. By way of this petition, under Article 2 to 6 of the Constitution of India, the petitioner is assailing the impugned order dated 19/7/2023, whereby the appointing authority has dismissed the petitioner from service has been pleased to dismiss the petitioner from service. Stop. The facts of the case is that the petitioner was appointed as an assistant science teacher at Gandhinagar ME School, Guwahati, and after rendering 2 years of service in the said post, the petitioner was appointed as assistant audit officer in the office of the Director of Audit (Local Fund), Guwahati, on 19/5/1994. Whereafter, the petitioner joined the said post and started discharging his duties. Stop. Thereafter, the petitioner was promoted as audit officer on 16/9/2005 and was posted at Viswanath Chariali under the office of the Assistant Director of Audit, Tejpur. And later on, he was promoted as Finance and Accounts Officer (FAO) in the month of January 2013 and was posted in the office of the Deputy Commissioner, Kamrup. It is the further case of the petitioner that the petitioner was transferred from the office of the Deputy Commissioner, Kamrup, to Hamrin Sub-Treasury as Treasury Officer with a notification dated 12/12/2013, and subsequently the petitioner was also given the additional charge of FAO in the office of the Deputy Commissioner, West Karbi Anglong District. It is the further case of the petitioner that after serving in the said capacity for few years, the petitioner was again transferred to DIFU Treasury as Treasury Officer with additional charge of Treasury Officer Bokajan Sub-Treasury VDA notification dated 5/1/2018. It is the further case of the petitioner that this whole thing, one second, Doctor. Mr. Patwari, this entire allegations were during the period you were holding the post of Treasury Officer at DIFU.
Yes.
Correct?
On 31st of March 2019.
19. It is the further case of the petitioner that while he was holding the post of Treasury Officer at DIFU, as stated above,
Page 8, second
pursuant to a
Page 8, second para.
pursuant to a search carried out by the jurisdictional police, certain cash was recovered from the office chamber of the petitioner, pursuant to which an FIR was lodged, being DIFU PS case number 70 of 2019 under section 120 bracketed B stroke 406, 403, 420 IPC. And ultimately, the petitioner was placed under suspension. Stop. Accordingly, a departmental proceeding was conducted and the inquiry officer submitted his report on 29/1/2022 to the disciplinary authority, ruling in favor of the petitioner. Stop. However, the authorities, by letter dated 21/2/2023, however, the respondent authorities thereafter, by letter dated 21/2/2023, forwarded the said report to the petitioner seeking his response. And though the finding of the inquiry officer was in favor of the petitioner, the respondent authority dismissed the petitioner from service by order dated 19/7/2023. Stop. Aggrieved by the aforesaid dismissal order, the present writ petition has been filed. Stop. Mr. Patwari, learned counsel for the petitioner, submits that the report of the inquiry officer is in favor of the petitioner, wherein the inquiry officer has clearly acquitted the petitioner of the charges leveled against him by the disciplinary authorities. He further submits that the second show cause notice issued to him by enclosing the said inquiry report was duly replied by the petitioner seeking exoneration from the charges and also reinstating him in service as per the said inquiry report. As per the findings of the said inquiry report. Stop. He further submits that shockingly, the respondent authorities, instead of accepting the inquiry report, which was in favor of the petitioner, dismissed the petitioner from service. He further submits that the said action of the respondent authorities is per se illegal, null and void, inasmuch as no opportunity whatsoever was provided to the petitioner before disagreeing with the conclusion of the inquiry report as regards acquittal acquittal of the petitioner from the charges leveled against him. He further submits that Rule 9A of the Assam Service within bracket Discipline and Appeal Rules 1964 mandates that before the disciplinary authority in the event the disciplinary authority is not accepting the findings of the inquiry authority, comma, it is incumbent upon the disciplinary authorities to furnish a copy of the report of the inquiry authority and a statement of the findings of the disciplinary authority, together with brief reasons for its disagreement, if any, with the findings of the inquiry authority. He submits that it is manifest apparent on the face of the record that no such statement of disagreement of the inquiry report has been submitted to the petitioner before issuing the impugned penalty. Stop. He further submits that in support of the aforesaid submission, he relies upon the he relies upon the following decisions of the Apex Court. Number 1, 1998 7 SSC 84. अपने तो पूरा हेरिटेज दिबो हाँ. Paragraph 17. 17 and 19, na?
Yes.
17 and 19.
17 is the core, 19 is the repetition.
Roman 2 dibo. Ram Kishan, 1995 6 SSC 157. Paragraph 10. Full dibo. He further submits that he further, by drawing attention of this court so many flags I have put to the definition of preliminary inquiry as contained under clause 8 of rule
Manual of Department Proceedings.
of the manual of departmental proceedings that a preliminary inquiry is not a departmental inquiry. In support of the aforesaid, in order to buttress the aforesaid, he further cites the following decision of the apex court. 1. AIR 64 Supreme Court 1854, paragraph 1213, and 2000 volume 13 SSC.
No, 2013 for
Huh?
2013 volume 4.
2013 volume 4 SSC 301, page paragraph 52.2. Per contra, Mr. R. Borpujari, learned, you're appearing as learned standing counsel, Finance Department, vehemently opposes the arguments of the learned counsel for the petitioner and submits that the second show cause notice
Page 63.
submits that the departmental authorities had forwarded the copy of the inquiry report to the petitioner for submitting his written reply, and the report indicates that there are materials against the petitioner on the basis of which the charges level has been proved, and hence he submits that the principles of natural justice is fully met in the instant case. He further submits that the inquiry officer, while conducting the inquiry against charge 1 and charge 2, has clearly stated that both the charges have been proved, and therefore, simply because at the conclusion the inquiry officer has acquitted the petitioner from the charges leveled, does not mean that the inquiry report is in favor of the petitioner. In view of the aforesaid submission, he further submits that in context of the aforesaid, he submits that Rule 9A therefore is not applicable in the facts of the instant case, inasmuch as there was no disagreement as envisaged under 9A of the rules. Correct? Basically, that was your submission.
Yes, I'm so grateful, Mr.
Anything else? This is the main.
Yeah, this is what is called out.
He further submits that the charges proved are grave, and therefore the impute dismissal order warrants no interference from this court. Stop. I have given my prudent considerations to the arguments made by both the learned counsels and have perused the materials available on record and has also considered the citation submitted at the bar. It is apparent from the inquiry report dated 2/2/2022 that though the inquiry officers had held charge 1 and charge 2 initially to have been it is apparent from the inquiry report dated so and so that upon consideration the inquiry officer has held charge 1 has held that the petitioner may be reasonably acquitted against charge number 1, and with regard to charge number 2 the inquiry officers held that it is felt that not much deliberation is required. In other words, the clear, unambiguous finding of the inquiry officer appears to be in favor of the petitioner. Pursuant to the aforesaid inquiry, it appears that the respondent authorities, by letter dated 21/2/2023, furnished the said inquiry report of the departmental proceeding to the petitioner by directing the petitioner to submit written reply within 7 days from the date of receipt of the aforesaid letter. Stop. The second show cause notice dated 21/2/2023 is reproduced hereunder for ready reference. A to A, page 63. Pursuant to receipt of the aforesaid notice, the petitioner on 2/2/2022. No. Where is your reply?
Look, 3 annexer 14, page 85.
Page 85.
3/3/2020.
This notice is, the date is correct, right?
Yes. Inquiry report was submitted in the year 2022. They took 1 year. That's why Papa is not.
No, but this date is otherwise correct, right? 21/2/2023.
Yes.
And your reply is at page
85.
The petitioner, by his reply dated 3/3/2023, requested the state respondent that in terms of the recommendation of the inquiry officer, the petitioner may be reinstated in service and also requested the respondent state authorities to accept the said report of the inquiry conducted against him and exonerate him of all the charges in terms of the said inquiry report. Stop. It appears that thereafter, the respondent authorities, by order dated 19/7/2023, awarded the punishment of major penalty of dismissal from service, which shall ordinarily be a disqualification for future employment, and accordingly remove the petitioner from service. Apt to refer to the impugned order dated 19/7/2023, which is reproduced hereunder for ready reference. B2B, page 87. Pertinent reading, reading of the aforesaid impugned termination or dismissal order, comma, it is apparent that the respondent authorities have relied on the preliminary inquiries as well as the inquiry report and have come to the conclusion that the petitioner has violated the procedures and have also received bribe, which amounts to misconduct. Stop. Before proceeding further in the matter, pertinent that the inquiry report, that the disciplinary inquiry which was conducted against the petitioner clearly acquitted the petitioner from the charges leveled against him. That being so, the question that arises for adjudication in the present writ petition is whether the order of the dismissal passed by the disciplinary authorities without giving the reasons for disagreement of the conclusion of the inquiry report is valid and legal. Pertinent to apt to refer to capital 9A of the Assam Services Discipline and Appeal Rules 1964, which is reproduced hereunder for ready reference. Quote unquote, page 438. Reading of the aforesaid provision, it is manifest apparent that in the event the disciplinary authority is not accepting the findings of the inquiry authority, comma, it is mandatory for the disciplinary authority to furnish a copy of the report of the inquiry authority along with the statement of the findings of the disciplinary authority, together with brief reasons for its disagreements before proceeding in the matter. Reading of the show cause, reading of the purported second show cause notice dated 21/2/2023 amply demonstrates that no such finding of the disciplinary authority nor the reasons for nor the reasons for disagreements have been furnished to the petitioner before taking a decision of imposing penalty, major penalty to the petitioner. That being so, the impugned dismissal order is manifestly and palpably illegal, null, and void on the face of the records. Stop. Undoubtedly, the charges leveled are grave in nature, comma, but the same shall not absolve the respondent authorities to violate the basic procedure of law. Stop. Since this court is of the considered opinion that due to non-communicating the findings of the disciplinary authority and the reasons of disagreement, the impugned dismissal order stands vitiated, comma, this court at this stage is not going into the other issues raised by the parties on merit and keeps the same open. Accordingly, the dismissal order dated 19th July 2023 is set aside and quashed. You are seeking reinstatement.
Yes, my lord. Prayer is there, my lord.
Resultantly, the petitioner is directed to be reinstated in service in accordance with law. It is further observed that on the reinstatement, however, taking into consideration the nature of charges, respondent authorities, if so advised, may proceed from the stage of issuing the second show cause notice against the petitioner in accordance with law. On reinstatement, what about his back wages and all?
He will be entitled for all the service benefits.
It is needless to be clarified that on the reinstatement as directed above, the petitioner
Would be entitled to all his service benefits.
would be entitled
To all his service benefits.
would be entitled only for the notional benefits.
Service benefits.
Service benefits.
Service
It will
benefits
include everything in accordance with law.
in accordance with law. The writ petition accordingly stands allowed in terms of the observation and directions made above. No order to cost.
I'm obliged to your lordship.
You definitely made a point as regard that preliminary and all that, but I don't think this is the right stage to go into all that.
Yes,
And another thing, Mr. Borpujari, if you see your inquiry report, that page 65 and 66, where you showed me the charge 1 and charge 2, if you see carefully, this is the charges which were leveled.
Quoted.
That has been quoted.
Show cause notice
That has been quoted. Thereafter,
all the inquiries are quoted.
if you see, all the reports and everything has been quoted. So why I'm pointing this out to you is that you have already seen. You see, the preliminary inquiry and the departmental inquiry are two different things.
Procedurally, my lord, he has spelled out everything.
That is why I said I have kept the contentious issues open.
I'm so grateful, my lord.
My lord, I'm obliged to your lordship for bearing me with all my shortcomings, my lord.
Yes.